Thank you, Courtney. Thank you for GRS for hosting today. Thank you, Jeff, for coordinating everything. Yes, so my name is Danielle Brennan. I am an attorney with Kaye Bender Rembaum here out of our Palm Beach Gardens office. Kerstin Henze is our attorney and managing the Tampa office. She will be joining us again later for the second half of the presentation. I will take care of the first portion. Kaye Bender Rembaum, we solely provide expert legal services to community associations throughout the state of Florida. We have 23 attorneys. 9 of us are board certified, including myself in condominium and plan development law, and 1 is certified in construction law. We do all of our collections, litigation, everything in-house. We offer a username and password for all of those associations that join us for our collections, so you can always view the status of collections online. Go to kbrlegal.com. We have a wealth of information, articles that have been published, and our calendar of events, because we do many events just like these throughout the year. This is our bread and butter. This is what we do day in, day out. There are very few things that come across our desk in a community association capacity that we have not seen before. So like Courtney said about your management company, if you have an attorney and you guys are happy with your attorney, fantastic. If you guys are shopping around for a new attorney or want a second opinion on something, contact us here at KBR Legal. All right, so that's our little spiel about the firm. Now let's talk about the course. So a lot of comments we get are, the course is too long, things don't apply to me. Apologies up front, but blame the Florida legislature, because they're the ones who force us to have the course be 4 hours long, and it has to cover certain topics. So the first portion is going to include topics such as structural integrity reserve studies and milestone inspections. Yes, we realize that does not apply to all condominiums throughout the state of Florida, but it is important for everyone to know, and it is required pursuant to Florida statute. So if you are a homeowners association board member, this is not the course for you. You're going to want to log off, go on to kbrlegal.com, our calendar of events, find the HOA board certification course and register there, because this is strictly for condominium association board members. Like Jeff said, stay on for the full time, get your certificate afterward. You should be receiving a copy of the presentation as well as part of the certificate. There should be a link there.
Yeah, we're going to,
and
within the, Danielle, pardon my interruption, within 5 to 7 days, we will be sending out the certificate after we verify full attendance for everybody, and it'll have a link for the slides as well.
Great. I think that's it. Remember that this program is for educational purposes only. We're not providing any legal advice, not creating that attorney-client relationship here. This is merely for education. If you have any further questions, you can feel free to contact us or reach out to your own association attorney to ask specific questions for your association to get that legal advice. All right, so let me go ahead and start sharing.
And Kerstin is here as well. And Kerstin, you'll join us back in about 90 minutes or so. Good morning to you as well over in the Tampa area.
Yes, hello everyone. Again, my name is Kerstin Henze, and I'm one of the partners and managing attorney of the West Coast office for the firm, which is located in Tampa. I've been with the firm since 2010, practicing, I don't know, much longer than that.
That's my joke with all these. We all started when we were 10 years old. So here we are.
All right, I'm going to be doing the latter portion, presenting the latter portion of the webinar, which will cover topics 3 and 4, such as fining, suspension of use rights, budget, reserves, notice requirements, and other topics. So I'll see you shortly.
See you a little bit later.
All right. I did also forget to mention that we have our offices in Pompano Beach and in the Orlando area, and you can get us in Miami-Dade by appointment as well. So let me go ahead and do the share on this. Are you seeing the PowerPoint presentation?
Just give it usually a few seconds delay after you do it. Not yet.
And it probably is showing you the wrong.
I'm still see. Hang on a minute. Let me make sure. Right now, I'm still seeing you. Can somebody verify in the Q&A if you're seeing the PowerPoint?
I hit the share.
Yeah, no. People are saying not yet.
Okay, so let me see.
Thanks, everybody. You can stop. I have a lot of questions. There we go.
Is it going now?
It's starting to. Yeah, now we see it, Danielle.
Okay, perfect. All right, so this is some information about the firm that we just briefly discussed. You'll have all this information for you. Again, you'll receive a copy of this PowerPoint. There's additional information about myself and about Kerstin here, just our little biography blurbs. And we'll go ahead and jump into topic 1. So topic 1 does cover the milestone inspection requirements and the structural integrity reserve studies. This is not going to be applicable to all condominium associations. However, it is very important to understand because it will still affect the condominium marketplace. All right, so first with milestone inspection requirements, what is a milestone inspection? Well, it's a structural inspection of the building, including the load-bearing elements, the primary structural members, and the primary structural systems. The primary structural members being structural elements designed to provide support and stability for the vertical and lateral loads of the structure, and the structural system being a combination of those structural members. It's performed by an architect, engineer, or a team of professionals that's led by an architect or an engineer. And the purpose is to attest to the life safety and adequacy of the building's structural components and, to the extent reasonably possible, determining the building's general structural condition as it affects the building's safety, and to determine if there's any necessary maintenance, repair, or replacement to a structural component of that condominium building. A milestone inspection is not to determine if that building meets Florida building code or the fire safety code. It's just to evaluate the structural condition of the building and to determine if any maintenance, repairs, or replacements are required for those structural components. Do you need a milestone inspection? Well, if you have a condominium building of 3 stories or more in height, as determined by the Florida building code, then you're going to be required to do a structural integrity, or I'm sorry, a milestone inspection for your residential condominium. Now, I say residential because you can have a condominium that has those commercial components, maybe a hotel component, something like that, in a vertical subdivision. So it's going to be applicable to your residential portion. If you're purely commercial, you're not going to need to do a milestone inspection. Or if you're a single family, 2-family, 3-family, or 4-family dwelling with 3 or fewer habitable stories above ground, you do not need a milestone inspection. Note here that the 4-family is underlined because that was recently added by this last legislative session. For mixed use and condominium hotels, the milestone inspection report has to be arranged by the residential condominium association and any owner of the portion of the building which is not subject to that condominium form of ownership. They're each responsible for ensuring compliance with the requirements in the milestone inspection, and then the condominium association is responsible for the costs of their portion of milestone inspection, and then the other owner will be responsible for their own costs. Now that you've determined that you need a milestone inspection, when does it need to be done? So the initial milestone inspection must be performed by December 31st of the year in which the building reaches 30 years old. Well, when do we start calculating the age of the building? It's based upon that certificate of occupancy for which was issued for the building. If the date of issuance for that certificate of occupancy is not available, then the date of issuance of the building's certificate of occupancy is evidenced by any record of the legal building official. If a building reached 30 years before July 1st of 2022, the initial milestone inspection should have been completed by December 31st of 2024. If a building reached 30 years after July 1st, 2022, but before December 31st of 2024, then the milestone inspection has to be completed by the end of this year, December 31st of 2025. Then you won't need another milestone inspection for another 10 years from that date of that previously submitted milestone inspection. The local enforcement agency can require that the initial milestone inspection be performed before that 30 years of age mark. It could be up to the 25 years of age mark, based on local circumstances such as being close to the ocean, because we know that the salt water is more corrosive to buildings. So certain circumstances may dictate a shorter period of time as determined by the local enforcement agency. They can also extend the due date for the initial milestone inspection if there's good cause that the inspection cannot be timely completed. If the association has entered into a contract with an architect or an engineer to perform the milestone inspection and it can't reasonably be completed before the deadline, or there's some other circumstance to justify the granting of an extension. If you have a report regarding the structural components of the building that's prepared before July 1st of 2022, that report may be acceptable if the inspection and report substantially comply with the milestone inspection requirements, which we'll discuss what those requirements are later. But perhaps you have maybe a 40-year recertification that you might like to submit to qualify as a milestone inspection report. Regardless of when the inspection was completed, the association still has to comply with providing unit owner notice, which we will also talk about very shortly. If a previous inspection report is accepted by the local enforcement agency, then that report and inspection is deemed to be the milestone inspection that satisfies the requirements of the Condominium Act, which is our Chapter 718 of Florida statutes. And the deadline for filing that subsequent 10-year milestone inspection is based on the date of the accepted previous inspection. So now that you need a milestone inspection, you know when it's due, what happens now? So once it's determined that a building must have a milestone inspection, the local enforcement agency is going to provide the association with written notice of the need to provide that milestone inspection report. And to any other owner of a portion of that building, let's say if it's not a residential portion, all right, it's going to get sent by certified mail, return receipt requested. The association must then notify the owners of the required milestone inspection within 14 days after receiving that notice from the local enforcement agency, and provide in that notice the date that the milestone inspection must be completed. Now, the milestone inspection consists of two phases. Phase 1, which is a visual examination, and phase 2, which is destructive or could have non-destructive testing depending upon what the architect or engineer determines. So let's dive into what these two phases consist of. For our phase 1, like I said, this is a visual examination, and it's of the habitable and non-habitable areas of a building, which includes the major structural components and provides a qualitative assessment of the structural conditions of the building. And when we're talking about these structural components, we're talking about foundation, masonry bearing walls, floor and roof systems, steel framing systems, concrete framing systems, windows, doors, wood framing, and the building's facade. The architect or engineer who performs the phase 1 milestone inspection has to prepare and submit an inspection report. There's, at least in Palm Beach County, I know that there's a website portal that you go to, then the engineer will fill out all the information, or the architect will fill out all the information that's required and submit the report via this online portal. Some other local enforcement agencies may have a similar process, but whoever you retain to do the milestone inspection will, or at least very much should know how to submit that milestone inspection to the local enforcement agency. All right, so that phase 1 inspection has to be completed within 180 days after receiving the notice that one needs to be performed from local government, from that local enforcement agency. Completion means that the engineer or architect who did the phase 1 inspection submitted the inspection report by email, US mail, or commercial delivery service to that local enforcement agency. Again, check with your local enforcement agency to determine how they prefer to receive the milestone inspection. If there are no signs of substantial structural deterioration found during the phase 1, you don't need to do a phase 2. So what is substantial structural deterioration? Well, it's substantial structural distress or substantial structural weakness that negatively affects a building's general structural condition and integrity. That probably doesn't mean much to lay people like ourselves, but to engineers, that means something. Engineers and architects, that means something. Unless the engineer or the architect that performs the inspection determines that surface imperfections are a sign of substantial structural deterioration, they're not going to be considered substantial structural deterioration. And these are things such as cracks, sagging, signs of leakage, peeling of the finishes. That's not going to be determined substantial structural deterioration unless there's cause for the engineer or the architect doing the inspection to believe that it is. So if we do have that substantial structural deterioration, then we have to do a phase 2 milestone inspection. This can involve destructive or non-destructive testing at the inspector's direction. The inspection may be as extensive or as limited as necessary to assess those areas of structural distress, to confirm that the building is structurally sound and safe, or to recommend a program for fully assessing and repairing the distressed and damaged portions of the building. If that phase 2 inspection is required, then within 180 days after submitting that phase 1 inspection report, the architect or engineer who's doing that phase 2 inspection must submit a phase 2 progress report to the local enforcement agency with a timeline for when that phase 2 inspection is going to be completed. The inspector who finishes the phase 2 inspection, milestone inspection, has to prepare a report and submit an inspection report to the local law enforcement agency. Same with the phase 1 inspection. Once a phase 1 or phase 2 inspection is completed, the architect or the engineer who did the inspection has to submit a sealed copy of the inspection report with a separate summary of the material findings and recommendations in the report to the association, to any other owner, which is not subject to the condominium form, perhaps, like again, either as a commercial component or something, and to the building official. The inspection report does have certain requirements, and it has to minimally include the seal and signature of who the architect or engineer that performed it, indicate the manner and type of inspection that was forming the basis of the inspection report, identify if there's any substantial structural deterioration, describe the extent of the deterioration, and identify any recommended repairs for such deterioration. State whether unsafe or dangerous conditions were observed, recommend any remedial or preventative repair for any of those items that are not substantial structural deterioration, and identify and describe any items requiring further inspection. Now, this isn't necessarily provided by Florida statutes, but when the body that does the Florida Building Commission, when they adopted regulations concerning the implementation of the milestone inspection, they did also add in here that a building official has to be notified if unpermitted work is discovered in the structural components. So even though they're not checking to make sure that things are going to be to code, they are checking to make sure that the work, whatever work was done, was permitted. So once we have our milestone inspection done, and it's been submitted, then within 45 days after receiving that inspection report, the association has to distribute a copy of the inspector prepared summary to each owner. Whether it's good or bad, you can't determine. You just need to send out that inspector prepared summary. And it can be sent by mail, personal delivery, or to email if the owner has consented to receive notice via electronic transmission. The association must also post a copy of that inspector prepared summary in a conspicuous place on the condominium property and publish the full report and inspector prepared summary on the association's website if the association is required to have a website. And those website requirements will be discussed later on in the presentation. The local government enforcement of making repairs. So the Board of County Commissioners or the municipal governing body can adopt an ordinance requiring that repairs be made for substantial structural deterioration. It be scheduled or commenced within a specified time frame after receipt of that second phase inspection report. However, the repairs must be commenced no later than 365 days after receiving the report. If the owner of the building fails to submit proof that repairs have been scheduled or have been commenced for substantial structural deterioration that may be identified in phase 2, within that required time frame, then the local government must review and determine if the building is unsafe for human occupancy. So it is very important that you're meeting all of these deadlines. Let me see here. This is something also provided by the Florida Building Commission. After all required repairs have been completed, the original milestone inspector, meaning the architect or the engineer who performed that milestone inspection, has to re-inspect the areas noted in the original report, provide an amended report with a signed and sealed letter stating that all necessary repairs and corrections have been completed, and confirm that the building is acceptable for continued use under the present occupancy. All right, and it's going to be the building owner or that architect or engineer that is responsible to submit this updated correspondence or updated report to the building official. Now, this is very serious. You absolutely have to pay attention to these notices, these deadlines, these requirements, because if the officers or directors of the association willfully and knowingly fail to have a milestone inspection performed, such failure is a breach of their fiduciary duty. So very serious stuff here. A local enforcement agency may prescribe timelines and penalties with respect to compliance with these milestone inspection requirements. So you could have personal liability as an officer or director of the association for breach of fiduciary duty if you ignore the requirements to obtain the milestone inspection. Now, like I was mentioning before, the Florida Building Commission, they were required to adopt rules to establish the building safety program for implementing the milestone inspections, which they already did. And the building inspection program has to minimally include inspection criteria, testing protocols, such and such. Like I said, it's already been created, and the engineer or architect you retain to do the milestone inspection will know of all of these requirements. So we've talked about our milestone inspection. Now let's talk about the money side of it, which is our structural integrity reserve studies and mandatory reserves that come out of it. What is a structural integrity reserve study? Structural integrity reserve study, some people call it a CEUs, some people call it a CERS for short. I guess the most common is CEUs, so I'll try to say CEUs. It's a study of reserve funds that are required for future major repairs and replacement of these items, which are at a minimum, and may remind you of some of the items that are required for maintaining reserves prior to the initiation of the structural integrity reserve study requirements. So here we go. Roof, which we have already been doing reserves for. The structure, which includes the load-bearing walls and other primary structural members and primary structural systems, which we talked about in the milestone inspection portion. Fireproofing, fire protection systems, plumbing, electrical systems, waterproofing, and exterior painting. windows and exterior doors, and that's only if they're maintained by the association, so you're going to need to look in your governing documents for that information. And any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to do that work would negatively affect the items that are listed above. So let's go ahead and move on. So who needs a structural integrity reserve study? It's going to be a residential condominium that has a structural integrity reserve studied. Has to be done at least every 10 years if the building has at least 3 stories or higher in height, as determined by the Florida Building Code. So it's very similar to who is required to have a milestone inspection. 3 stories or higher, residential condominium, and has to be done every 10 years. Sounds familiar, right? Here's who does not need to have a structural integrity reserve study. If your building is less than 3 stories in height, single family, 2 family, or 3 family dwellings that have 3 or fewer habitable stories above ground. Note here that they did not add the 4 family dwelling like they did with the milestone inspection. Any portion or component of a building that has not been submitted to the condominium form of ownership, any portion of a building that's maintained by a party other than the association, like the unit owner, or commercial condominiums. They do not need to have a structural integrity reserve study. So what are the requirements? The structural integrity reserve study is based on a visual inspection of the condominium property. So it kind of is like a phase 1 milestone inspection. At a minimum, it has to identify each item of the condominium property that's being inspected, state the estimated remaining useful life and the estimated replacement cost or deferred maintenance of that item, and provide a reserves funding schedule with recommended annual reserve amount that achieves the estimated replacement costs or deferred maintenance of each item that is being inspected by the end of that useful life. So who can perform the structural integrity reserve study? It can be performed by any person qualified to perform such study. Yeah, that's actually provided in the Florida statutes. However, the visual inspection portion does have to be prepared by an engineer, architect, or someone that's certified as a reserve specialist or a professional reserve analyst by CAI or the Association of Professional Reserve Analysts. Now, an association existing on or before July 1st of 2022, which are unit owner controlled, must have a structural integrity reserve study completed by December 31st of 2024. So you should already have that in hand for each building in the condominium condominium property that has 3 stories or more in height. However, an association that's required to have a milestone inspection on or before December 31st of 2026 can complete the structural integrity reserve study at the same time as a milestone inspection, but in no event can the structural integrity reserve study be completed after December 31st of 2026. So if the milestone inspection is required or an inspection completed for similar local requirement, i.e. like a 40-year recertification requirement, was performed within the past 5 years and meets that structural integrity reserve study requirements, then you can use that inspection in place of the visual inspection portion of the structural integrity reserve study. And then you need to go and finish this other portion, which is determining the dollars and cents. So you've gone out, you've gotten your CEUs, your SEERs. Now what? Within 45 days after receiving that study, the association has to distribute a copy to each owner or provide each owner with notice that the completed study is available upon written request. And a copy of the study or the notice must be sent by mail, personal delivery, or it can be sent by email to those owners who have consented to receiving notice by electronic transmission. And the association must also provide the division, being the Division of Florida Condominiums, Timeshares, and Mobile Homes, with a statement informing them that the study was completed at the association provided the copy or made the copy available to each unit owner within that 45-day requirement. The statement has to be provided to the division in the manner that's established by them using a form that's posted on the division's website. If you guys have not gone to the Division of Florida Condominiums, Timeshares, and Mobile Homes website, I would suggest taking a look because there are a lot of resources there available to boards. Now, that structural integrity reserve study has to be maintained for at least 15 years after the study is completed as part of the association's official records. And for those associations that are required to have a website, you have to post the structural integrity reserve study on the website, or perhaps you may have a mobile app. You can post it there as well. Same with the milestone inspections. If the officers or directors of the association willfully and knowingly fail to complete a structural integrity reserve study, such failure is a breach of their fiduciary duty. So you want to make sure that you're maintaining these deadlines and keeping up with these requirements. Now, if your association is required to have a structural integrity reserve study, then you have to maintain reserves for the items which are in the structural integrity reserve study. The reserve amount for these items must be based on the findings and recommendations provided in that structural integrity reserve study. And the association can adjust those replacement reserve assessments annually to take into account inflation, changes in estimates, or extension of the useful life of that item by conducting deferred maintenance. Perhaps you do something, change a component of something that extends the useful life by another year or so. You can adjust the reserves for that extension of useful life. Now, if the item does not have an ascertainable life, or the estimated remaining useful life is greater than 25 years, the association is not required to reserve replacement costs for those items. However, the association must reserve the amount of deferred maintenance expense, if there's any, which is recommended by the structural integrity reserve study for those items. And here, a foundation. What's a useful life of a foundation? It should last you forever, hopefully, right? So it's for items like that that may have a reserve exemption. Now, waiving and reducing reserves. I'm sure that a lot of condominium associations, in an effort to lower their overall assessment requirements, have waived or reduced reserves throughout the years. And that still remains possible for non-Sears reserves. So the members of a unit owner controlled association can determine upon a majority vote of the total voting interests to provide no reserves or less reserves than are required by statute. However, now for a Sears reserve item, that's not going to be possible. Sears reserve items have to be fully funded and you cannot waive or reduce them. All right. There is a possibility to provide for alternate funding methods for a condominium, multi-condominium having at least 25 condominiums. And there are alternate funding methods available, but for the most part, your condominium association, if you're required to have a Sears, you're required to have fully funded Sears reserves. All right, so for those associations that are required to have a Sears study, you're again required to fully fund your Sears reserves, but you cannot then use those monies for something else. So for our non-Sears reserves, we know that we can use those monies for some non-reserve purpose upon the approval of a majority of all the voting interests of the association. However, at this point, if you have Sears reserves, you're not going to be able to use those Sears reserves funds for anything except for those Sears reserve items. So pooling. Pooling is something that's not expressly provided for in the Condominium Act. again, being Chapter 718 of the Florida statutes. But generally speaking, we create a pool by getting a vote of the owners to use reserves for other purposes, because the monies, although earmarked for reserves, are earmarked for a group of assets, and the dollar bill is fungible for any one of those assets, right? But when you have CERS reserves and non-CERS reserves, I would not pool all those together. You may be able to pool your structural integrity reserve items together, but not with non-CERS reserve items. If the local building official determines that the condominium building is uninhabitable due to a natural emergency like a hurricane, flood, drought, or earthquake, then the board, upon approval of a majority of the members, can pause contributing to the CERS reserves or reduce that reserve funding until it's determined by the local building official that the building is habitable. Any reserve funds that are held by the association can be used pursuant to board's determination, meaning board action alone without the need to attain membership approval, to make the condominium and its structures habitable. Once it's determined by the local building official that the condominium building is habitable, then the association has to start contributing to its reserves again. All right, so we've discussed our milestone inspections. We discussed our structural integrity reserve studies. What else is there? Notwithstanding when the certificate of occupancy was issued or the height of the building, a developer must include with its turnover inspection report, so this is just a portion of that turnover inspection report, a structural integrity reserve study attesting to required maintenance, condition, useful life, and replacement costs for the roof, the structure, which includes the load-bearing walls and those primary structural members and primary structural systems, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, and windows and exterior doors. And unit owners are required to have disclosures. Each contract for the sale of a residential unit must contain in conspicuous type certain disclosures regarding the milestone inspection or structural integrity reserve study. A contract that does not have these disclosure requirements is voidable at the option of the purchaser prior to closing. If the association is not required to have a milestone inspection or a structural integrity reserve study, then the sales contract must contain in conspicuous type a statement indicating that the association is not required to have these items. If the association is required to have the structural integrity reserve study and the milestone inspection or a milestone inspection and has not completed it, each contract for sale of the residential unit must contain in conspicuous type a statement to that nature. The association is required to have it and has not completed it. If the association is required to have it and has completed it, then the contract for sale of the residential unit must contain in conspicuous type the disclosures that are provided by Florida statute. They're not copied here, but you can certainly go to this Florida statute and see what the disclosure requirements are. Each prospective purchaser who has entered into a contract for sale of the residential unit is entitled to, at the seller's expense, a current copy of the inspector prepared summary of the milestone inspection report and the association's most recent structural integrity reserve study. Now, note that this is not an exhaustive list of what is required to be provided to the purchaser. This is just what's relevant to this portion of the discussion. After these reports are provided, then the buyer has a 3 business day right to cancel that contract, which is huge. So you want to be sure that you're providing those inspection reports and the summary to the purchaser when they're signing the contract to get rid of that 3-day right of rescission. And the right to void the contract cannot be waived. So the buyer can't say, oh, no, never, I don't want to do that. Let's just go ahead and go through with the contract. No, it cannot be waived by the buyer. You do have to comply with it. Now, disputes regarding milestone inspections and the CEUs. So the term dispute, as used in this particular section, which is with regard to alternate dispute resolution. So this particular statute requires that certain disputes, as they're defined in this statute, go to either non-binding pre-suit mediation or to, mandatory pre-suit mediation or non-binding pre-suit arbitration with the Division of Florida Condominiums, Timeshares, and Mobile Homes. The term dispute has been expanded to include the failure to obtain the milestone inspection, the failure to obtain a structural integrity reserve study, the failure to fund reserves as required by the structural integrity reserve study, or the failure to make or provide necessary maintenance or repairs of the condominium property that's recommended by the milestone inspection or a structural integrity reserve study. However, these items are not subject to mandatory non-binding arbitration, but they are required to go to pre-suit mediation. And if it's not resolved at mediation, then you can go to litigation. Now, changing topics entirely. So that is the portion that's not going to be applicable to all condominiums throughout the state of Florida because it really only has to do with 3 stories or higher for residential condos. But the next topic that we're getting into is absolutely applicable to our condominium associations. So everyone, listen up. Starting with elections. When do you need an election? Well, when a term expires, the seat of that expired term of that expired director's is going to be filled by an election. And if there's a vacancy on the board caused before the expiration of a term, maybe they resign or they are disqualified, then it's filled by a majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director, or the board can choose to hold an election. Now, mind you, this is how a vacancy is filled if the vacancy is created other than the expiration of the term and not by recall, because recall has its own requirements for filling vacancies created by that recall. So our general election timeline, just remember 60, 40, 35, 14. Right, so not less than 60 days before the election, you're going to be sending out that first notice of the date of the election to your owners. It can be sent by mail, delivery, electronic transmission. Again, electronic transmission requires written consent from the owner to send notice via electronic transmission. The unit owner or other eligible person who wants to run for the board has to give written notice to the association not less than 40 days before the scheduled election of their intent to run for the board. The candidate can also provide a candidate information sheet to the association not less than 35 days before the election. And that candidate information sheet has to be no larger than an 8.5 by 11 sheet of paper, one-sided, and you must include it with the second notice of the annual meeting, which has to be sent to the owners not less than 14 days, no more than 34 days before the annual meeting or election. Now that's going to be the notice, agenda. You're going to be sending the candidate information sheet, your ballot envelopes. All of that gets sent with your second notice of the annual meeting and election. That ballot will be required to provide all candidates alphabetically by their last name. Generally speaking, unless otherwise provided in your governing documents, the board is going to consist of 5 members. Unless there are 5 or fewer units, then the board will consist of at least 3 members. If the articles of incorporation or the bylaws permit directors to serve longer than 1 year, then their terms are going to expire at the annual meeting unless the condominium is a timeshare non-residential condominium or there's a staggered term, perhaps you have a 2-year or 3-year staggered term, and that director's term is not expiring until a later annual meeting, and unless all directors' terms would otherwise expire, but there are no candidates. So that would be like a rollover situation. A director cannot serve more than 8 consecutive years unless approved by 2/3 of all votes that are cast in the election, or unless there are not enough eligible candidates to fill vacancies on the board. Now, that 8 consecutive year calculation starts July 1st of 2018 when that law became effective. So whatever service occurred before July 1st of 2018 is not going to count toward that 8-year limitation. And again, there are exceptions to that limitation. In a residential condominium association having more than 10 units, the co-owners of a unit cannot serve as directors at the same time unless they own more than 1 unit, or unless there are not enough eligible candidates to fill the vacancies on the board. Mind you, that's serving as directors. That doesn't mean that they can't run at the same time. Perhaps one gets elected and one doesn't, right? So that's serving on the board, not necessarily running for the board. If there are not enough candidates to have an election, that's really an election by acclamation is what we call it. And then the candidates that are nominated get seated on the night of the annual meeting. So perhaps you have 5 seats that are opening up. You only have 4 people who have thrown in their names in the hat. Well, there's not going to be an election. Those 4 people will just get onto the board, and then they will then fill the vacancy on the board by their own vote. There's no quorum requirement to hold an election. However, at least 20% of the eligible voters must cast a ballot in the election. Elections are decided by a plurality of the ballots cast, meaning those candidates with the most votes are elected. If you own 1 unit and have 1 vote, and there are 5 candidates and 3 open seats, you cast 1 vote for your 3 top choices, and those 3 people who get the most votes will then be elected to the board. Ballots, sign-in sheets, voting proxies, any other papers that relate to voting by the owners in that election have to be maintained for 1 year from the date of the election, or until the next election. If it's later than that, we will go over more of these official record requirements in a little bit. Any challenge to the election process has to be commenced within 60 days after the election results are announced. An election challenge would go to the Division of Florida Condominiums, Timeshares, and Mobile Homes. Once you pass that 60-day mark, you will then have to initiate a recall. So what is a candidate? A candidate is any eligible person who has timely submitted the written notice of their intent to become a candidate. A person desiring to be a candidate, again, has to provide the board with written notice of their intent to run for the board not later than 40 days before the annual meeting and election in order to have their name listed on the ballot or to serve on the board. A person who is delinquent in the payment of any assessment due to the association as of that 40-day deadline is not eligible to be a candidate. A person who has been suspended or removed by the division under the Condominium Act is not eligible to be a candidate. A person who has been convicted of a felony or has been convicted of any offense in another state, which would be considered a felony here in Florida, is not eligible for board membership unless their civil rights, like their right to vote, right to hold public office, serve on a jury, have been restored for at least 5 years. Now, if they get on the board and it's later found out that they are in fact, a felon who has not had their civil rights restored for at least 5 years, the validity of the action by the board is not affected. So simply because they were on the board and made decisions doesn't mean that those decisions are now bad decisions. If there's a criminal charge pending against an officer or director, meaning a forgery of ballot, theft or embezzlement of association funds, obstruction of justice, then that person cannot be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association except pursuant to a court order. So even if the person is running for an election of a condominium board in your association, and they're a part of another association where they've been charged with embezzlement of association funds, that charge would make them ineligible to run for your association's board. As we know, voting is by secret ballot with our double envelope system. The proxy limiter general cannot be used in the election of members in a residential condominium building. The ballot, again, has all the eligible candidates' names in order by last name, can't have any kind of marks on it, like saying, oh, vote for this person. You can't have that. And then once they complete the ballot, they put it into an inner envelope, they seal that inner envelope, then it's put into an outer envelope that's addressed to the person or the entity that's going to be receiving the envelopes. They seal that envelope and then they put on the outer envelope their name, the unit or unit numbers that are being voted, and their signature. Now, it's very important that the association include spaces for this information to be provided on that outer envelope. The inner envelope can only contain one ballot. If a member is entitled to cast more than one ballot, then they have to use separate inner envelopes for each one of those votes, though they can send it in one outer envelope. If they're doing so, then they have to identify on the outside on the front of that outer envelope, the unit numbers, multiple numbers that are being voted for in that envelope. Again, the voter has to sign in the space provided and then either mail or hand deliver their ballot envelopes to the association. Once it's received by the association, they cannot change or rescind their ballot. And a unit owner cannot authorize another person to vote their ballot. Any ballots that are improperly cast are invalid. And a unit owner who violates this provision can be fined by the association. However, if a unit owner needs assistance in casting a ballot for blindness, disability, or inability to read or write, then they can obtain that assistance to complete and submit their ballot. Now the association's gotten all of their ballots. What can they do to maybe speed up the process of the election? Well, the association can verify that information provided on the outer envelopes before the election on the same day, right? Same day as the election, by noticing a meeting of an impartial committee that consists of members who are not current board members, officers, candidates for the boards, or any of their spouses. This meeting has to be open to all members, noticed like a board meeting. And here, a typical board meeting notice is fine, 48 hours notice, conspicuously posted on condominium property, and again, held on the same day as the election. So if your election is in the evening, you can hold this verification meeting in the morning to verify the information on the outer envelopes. In verifying that information, we look at the signature, the unit identification, and then we check it against a list of the qualified voters, right? And we say, okay, we've got their ballot, check. Any outer envelope that is not signed by the eligible voter is marked disregarded or words of similar import. And any ballots that are contained in that outer envelope are not counted. However, you do still have to maintain it as part of the association's official records. Now, there are some crimes provided by Florida statutes for fraudulent voting activities, criminal penalties, excuse me. A person who engages in a fraudulent voting activity related to an election, like using threats, bribery, or intimidation related to casting a ballot, commits a first-degree misdemeanor. Forgery of a ballot envelope or voting certificate used in a condominium association election is punishable as a third-degree felony. So there are serious crime penalties associated with condominium association elections. Go figure, right? Electronic voting. So an association can use an online voting system for all of their owner votes if first the board establishes online voting by a resolution, which we will discuss, and an owner opts in to online voting in writing. Now that consent to do online voting can be sent electronically or in writing by the owner. An owner who opts to vote electronically and does in fact vote electronically is counted as being in attendance at the meeting for the purposes of determining a quorum. So it is really helpful in that regard too. The use of electronic voting has to be established by board resolution that's made at a board meeting that's noticed in a manner similar to a membership meeting, meaning it has to be sent to the owners at least 14 days before the meeting, mail, delivery, electronic transmission. Again, if we're sending notice by electronic transmission, we have to have a written consent from the owner to do so. And must also be posted, conspicuously posted on the condominium property at least 14 days before the meeting. And all of that needs to be evidenced by an affidavit of the person who provides the notice. The board resolution has to provide that owners will receive notice of the opportunity to vote through the online voting system, establish reasonable measures and deadlines for owners to provide their written consent to opt into electronic voting, and establish reasonable procedures and deadlines for owners to then opt out of online voting. If online voting is used, the association must provide each owner with a way to authenticate their identity, a way to ensure this secrecy and integrity of the election ballots, and a method to confirm at least 14 days before the voting deadline that their device can communicate with the online voting system. The association's online voting system has to be able to authenticate the owner's identity, authenticate the validity of the vote, transmit a receipt to the owner, permanently separate the identifying information from the election ballot, because remember, it's a secret ballot, and store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, there are many electronic online voting service providers out there, and they will, if they're authorized to provide this service in Florida, they will be sure to comply with these requirements and will help you with setting up the system and getting those consents in from your owners to use electronic voting. For associations, not too many associations, with us have utilized electronic voting. But for those associations that have, it makes the process so simple because you literally get the tally at the click of a button. It's fantastic. If the board authorizes online voting, the first notice of the date of the election has to disclose the procedure and deadline to consent to electronic voting. So if you have online voting, that first notice of the election, which gets sent out 60 days before the election, has to provide, hey, you guys, we have electronic voting available. Here's how you can sign up. If the board authorizes online voting, the board must honor a unit owner's request to vote electronically at all subsequent elections unless they opt out of online voting. A vote of the unit owners may not be taken on an issue other than whatever is addressed in the electronic vote if the quorum is established based on unit owners voting electronically, right? Meaning you can't then present a new vote to the people who are physically in attendance when your quorum is established based on people who have voted electronically and won't have the ability to participate in that vote. So we've talked about our directors. Now let's talk about our officers. Unless otherwise provided in your bylaws, the board must have a president, secretary, and treasurer who perform the duties of offices customarily performed by officers of corporations. Unless prohibited in the bylaws, the board may appoint other officers and grant them duties as appropriate, like a vice president or perhaps an assistant secretary or assistant treasurer. Unless otherwise provided in the bylaws, the officers serve without compensation and at the pleasure of the board. Generally, officers are selected by the board immediately following the election of the directors at a meeting that's typically called the organizational meeting. Directors cannot vote by proxy or by secret ballot at board meetings. However, when they're electing officers, they can. And there's no prohibition against changing officers mid-term. So depending on what your governing documents say, you might be able to, or you should be able to change your officers at any time. Now, disqualification from service. An officer or director who knowingly solicits, offers to accept, or accepts a kickback commits a third-degree felony and is subject to a civil penalty. When you see civil penalty, that means dollars, and must be removed from office and a vacancy declared. A kickback is anything or service of value for which consideration has not been provided for that person's own benefit or the benefit of their immediate family from any person providing or proposing to provide goods or services to the association, right? I'll scratch your back, you scratch mine type thing. An officer or director charged by information or indictment for any crime that's provided in the statute, which includes forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, and others, is removed from office. If the charges are resolved without a finding of guilt, then that person must be reinstated for the remainder of the term if there's any remainder left. And finally, a director or officer, I'm sorry, not finally, there will be more, but finally for this slide, a director or officer more than 90 days delinquent in the payment of any monetary obligation due to the association is deemed to have abandoned their seat on the board, and they are then kicked off the board automatically. Notice that this says any monetary obligation due to the association. This isn't just assessments. This could be fines. A director who knowingly and willfully violates the official records inspections requirements 2 or more times within a 12-month period commits a second-degree misdemeanor and must be removed from office and a vacancy declared. That 2 or more times within a 12-month period is what the statute refers to as repeatedly. Any person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained by the association, or who knowingly or intentionally fails to create or maintain those accounting records that are required to be maintained with the intent of causing harm to the association or any of its members, commits a first-degree misdemeanor and is personally subject to a civil penalty, again, dollar bills, and must be removed from office and a vacancy is declared. A person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to help someone else do the same thing, commits a third-degree felony and must be removed from office and a vacancy declared. It keeps going, folks. A person who uses a debit card issued in the name of the association or that's billed directly to the association for any expense that's not a lawful obligation of the association commits theft and must be removed from office and a vacancy declared. So what is a lawful obligation of the association? It's an obligation that has been, properly pre-approved by the board and is reflected in the minutes of the meeting of the board or the written budget. If the board finds that an officer or director has violated the conflict of interest requirements, conflict of interest will be discussed later on in the presentation as well, then the officer or director is deemed removed from the office, creating a vacancy. A director who fails to file the written certification and educational certificate, which is what you'll receive after this, you fill out your evaluation form, and within 5 or 6 business days, get that certificate. If you fail to obtain your certificate, then you're suspended from service on the board until you comply with the requirement. The failure to have that written certification or educational certificate on file does not affect the validity of any board action. So all of you don't have to worry. So long as you stay for the whole time, fill out your evaluation form, you will receive your certificate. All right, so this discussion falls right into our Condominium Association website. You've heard me say several times that, well, if a website is required for your association, then you're required to post like the structural integrity reserve study onto the website. So what are those website requirements? As of right now, condominium associations having 150 or more units must have a website. As soon as January 1st of 2026 rolls around, that number is going to drop significantly down to 25 or more units. Now, this was implemented now, thankfully, by the legislature because there's going to be a growing pains here. So all of those associations with 25 or more units, but less than 150 that don't have a website, you need to start gearing up for it and start creating digital records because you will have these posting requirements. So the association's website has to be an independent website or web portal that's wholly owned and operated by the association, or you could have a website or web portal that's operated by a third-party provider with whom the association owns, lease, or rents, or obtains the rights to have that web page. And the web page can have a collection of sub-pages, what have you. Now, the website must be accessible through the internet and has to have a web page, web portal, or other protected electronic location that's going to be inaccessible to the general public and accessible only to the unit owners and the employees of the association. Once a unit owner makes a request, the association has to provide the unit owner with a username and password to access those protected sections of the website. Now, mind you, the official records of the association are really only for the members of the association. So all of that information does need to be posted on the internet, on the website, however, would be accessible only to owners via the username and password. Now, as far as what needs to be posted onto the website, it's a long list, so bear with me. A current copy of all of these documents, the declaration of condominium, bylaws, and any amendments to those documents, the articles of incorporation that are filed with the Department of State Division of Corporations, or other documents that create the association and the amendments to those documents, the rules, current rules of the association, a list of all executory contracts or documents to which the association is a party, or under which the association or the owners have an obligation. And after bidding for the related materials, equipment, or services has closed, a list of the bids received by the association within the past year. Now, summaries of bids for materials, equipment, or services that exceed $500 must be kept on the website or the mobile application for 1 year. And in lieu of summaries, you can simply provide the complete copy of the bid. You have to post the annual budget and any proposed budget that might be considered at an annual meeting, the financial report and any proposed financial report to be considered at a meeting, each director's certification, so the certificate that you receive from this presentation will need to be posted on that website. All contracts or transactions between the association and any director, officer, corporation, firm, or association that's not an affiliated condominium association, or any other entity in which an association director is also a director or an officer and financially interested. Essentially, any contract or document where there could be a conflict of interest will need to be posted on that website. All your board meeting notices, including the agenda and any document required for the meeting, must be posted no later than the date required for the notice. So this would be either the 48 hours before or 14 days before, depending upon what it is. Say you guys are adopting or implementing electronic voting. You would be posting that board meeting notice and agenda and a copy of the resolution on your association's website at least 14 days before the date of that board meeting, right? The notice of any owner meeting and the agenda for that meeting no later than 14 days before the meeting. Now, these notices have to be posted in plain view on that landing page, that very first page of the association's website, or on a separate sub-page labeled notices, but that sub-page notices has to be conspicuously visible and linked on that landing page. The association must also post on the website any document that's going to be considered and voted on by the owners during that meeting, or any document that's listed on the agenda at least 7 days before the meeting at which that item is going to come up for a vote. So, for example, if you guys are voting on an amendment to your declaration, you would be posting that amendment on the website at least 7 days before the meeting. Why is it 7 days as opposed to 14 days when you're posting the notice? I really don't know. So it's probably just easier if you post both at the same time, and you won't even have to worry about the 7 days. You also have to post that your most recent structural integrity reserve study, as we discussed, as well as any inspection reports that are related to the structural or life safety inspection of the condominium property. So you're going to be posting your milestone inspection. You'll be posting your 40-year recertification, something like that. Copies of all the building permits that were issued for ongoing or planned construction. So if it's past construction, there's no need to post it, although you still do need to maintain it as part of your official records. The failure to post these documents on the website does not, in and of itself, invalidate any action or decision of the association. The association must designate on its website a person or entity with contact information for receive a request for an estoppel certificate, and estoppel certificates will be discussed with Kerstin in the second half of the presentation. The association has to ensure that the information records that are not accessible to unit owners are not posted on the association's website, and we will discuss what those records are shortly. If there is protected information or information restricted from being accessible to owners included in documents that are required to be posted on the website, then the association has to redact all of that information before posting the documents. However, in complying with these posting requirements, there's no liability for disclosing information that's protected or restricted unless that disclosure was made with a knowing or an intentional disregard of the protected or restricted nature of such information. So it is important to go through your official records, see what has to be posted, go through those records, and make sure that any information that's not accessible to owners is redacted from that posted copy. And like I said, we will discuss what that is. A mobile application, you've heard me say it. Instead of having a website, you can use everything, a mobile app to make all those documents available. And the app does have to meet the same requirements as the website. And finally, official records, are our official records? Well, again, a very long list that kind of ends with catch-all. Any plans, permits, warranties that were provided by the developer, a copy of your governing documents, meaning your declaration, bylaws, articles of incorporation, amendments to those, a current copy of your rules, you really should, are also part of that. Meeting minutes, a roster of all unit owners, which includes their mailing addresses, unit identifications, voting certificates, and if known, their telephone numbers. The association must also maintain and make available for inspection their email addresses for those owners who consent to receive notice of association meetings via email or expressly indicated that the email can be shared with unit owners. Emails may only be used for the business operation of the association and cannot be sold or shared with outside parties. All your insurance policies, all the financial records, like your financial reports, accounting statements, accounting records have to include records of all receipts and expenditures, invoices, transaction receipts, deposit slips, current accounting on a monthly, bi-monthly, or quarterly statement for each of the units that shows the name of the owner, the due date and amount of each assessment, and the amount paid on the account and whatever balance might be due. A copy of the management agreement, bill of sale or transfer of all property owned by the association, your ballot, sign-in sheets, voting proxies, those documents that we talked about with regard to the election, all rental records of the association, if they are acting as the agent for that rental, a copy of the current question and answer sheet. Now, I get a lot of questions of people like, what is this question and answer sheet? It is a form that is developed by the Division of Florida Condominiums, Timeshares, and Mobile Homes that must be updated annually. The form is provided online. So, like I said, go to the division website. There are a host of materials there that you guys can take advantage of. And one of them that you must use is this question and answer sheet. A copy of all inspection reports, your bids for materials, equipment, and services, all affirmative acknowledgements. Now, affirmative acknowledgements have to do with the sending of invoices or statements with the financial management of the association. They will be discussed later on with Kerstin. board member educational certificates, like what you will receive from today, and all other written records that are not specifically identified that relate to the operation of the association. These are all going to be part of your official records. Now, how long do you have to maintain them? Mind you, these are minimums, right? All official records must be maintained for at least 7 years. However, these records have to be maintained from the inception of the association, meaning forever. A copy of the plans, permits, warranties, and other items that are provided by the developer. A copy of your governing documents, being your declaration, bylaws, articles of incorporation, all amendments to those. A copy of the current rules and all meeting minutes. Those have to be maintained forever. As we discussed before, your structural integrity reserve study and all inspection reports have to be maintained for 15 years. Bids for work to be performed for materials, equipment, or services have to be maintained for at least 1 year after receipt of those bids. And again, your ballot, sign-in sheets, voting proxies, any papers having to do with voting by owners must be maintained for 1 year from the date of that vote. And again, if it's an election, it's longer than the 1 year, depending upon when your next election is. The official records must be maintained in an organized manner that facilitates inspection of records by a unit owner. So if you guys have messy records, your physical records are all over the place, your electronic records aren't organized, you need to get to task and get them nice and organized. If the official records are lost, destroyed, or otherwise unavailable, then the association obligation is to maintain the official records. The obligation to maintain the official records, includes a good faith obligation to obtain and recover those records as is reasonably possible. To what extent the association has to go is really not known. This is a fairly new requirement. Like, for example, does the association have to obtain the assistance of like a forensic computer analyst? Don't know if that's going to be the benchmark there as far as costs and time are concerned. But you do need to make some kind of good faith effort to obtain and recover those records. Now, with regard to inspection and copying of official records, after receipt of a written request by the board or its designee, the association must make the official records available to an owner and to the owner's authorized representative. Must be within 10 business days of receipt of that written request and within 45 miles of the condominium or within the county in which the condominium is located. Renters do have some rights to the official records, but it's limited to the declaration of condominium, the bylaws, the rules, and the inspection reports. The association can comply with this inspection and copying requirement by having a copy of the official records available for inspection on the condominium property or the association property. So like you have them all organized in a box, filing box, something like that. Offering the option to make the records available electronically over the internet. And if they're posted on the association's website or app, the association can simply direct the owner to the website or to the application to obtain the records, and that would be deemed compliance. Or the association can allow the records to be viewed in electronic format on a computer screen and printed upon request. For example, if you want to have them come in and go through the association's computer because you have them all saved there, and then print them as they're needed, that would be deemed compliance. So that right to inspect the records includes the right to make or obtain copies at the reasonable expense of the member. The association has to allow the member or their authorized representative to use like a smartphone, a tablet, a portable scanner, free of charge to make their own copies in lieu of the association providing the copies. I have been to an official records inspection where someone did bring a printer that had a scan function. So not everybody uses their cell phone for these purposes. So they did in fact bring this heavy duty scanner. The association must maintain an adequate number of copies of the governing documents. Again, the declaration, articles of incorporation, bylaws, and amendments to them, and the current rules and regulations. The question and answer sheet. Again, you guys, you need to be making sure that you have this and updating it annually. And the year-end financial information on the condominium property to ensure their availability to owners and to prospective purchasers. Even though you do have to have these copies, you can charge the actual cost for preparing and furnishing them to those owners and prospective purchasers who are requesting the physical copy. So this is brand new. Once you receive that written request to inspect the records, the association has to provide the requester with a checklist of all the records that are made available for inspection and copying. And it must also identify any of the association's official records that were not made available to the requester. The association has to maintain this checklist for 7 years. And an association that delivers this checklist creates a rebuttable presumption that the association complied with its inspection and copying requirements, its obligations. Now, an association may and absolutely should adopt reasonable rules regarding the frequency, time, location, notice, and manner of records inspections and copyings. However, the association cannot require an owner to show any proper purpose for the inspection. Hey, why are you wanting to look at these documents? Or state any reason for the inspection, right? That's their business, not the association's business. As I was mentioning before, although records are required to be maintained as official records of the association, not all records are accessible to members by inspection. And here is the list of those records. Records that are protected by the attorney-client privilege or the work product privilege relating to litigation or adversarial administrative proceedings. The board holds the attorney-client privilege. The association's attorney does not. So only the board can waive that privilege. The association's attorney cannot. Information obtained by the association in connection with the approval of a lease, sale, or other transfer of a unit. Let's say your declaration authorizes the board to screen and approve or disapprove purchasers or tenants. Whatever information you obtain with that, like a consumer report concerning their criminal history or their credit history, would not be accessible to the members, although it would be maintained as official records of the association. Personnel records of the association or its management company, employees like disciplinary, health role, health and insurance records, those are not accessible to members. However, note that personnel records does not include the employment agreements with an association employee or a management company, or any budget or financial record that would show the compensation that's paid to that person. Medical records of unit owners, and some of you might be like, why would I have possession? Why would the association be in possession of medical records of unit owners? Well, the famous assistance animal scenario where, somebody needs an animal because they have perhaps a physical disability and requires, the dog to guide them or push buttons with their nose or what have you. All of that would be part of the official records, but not accessible to the owners. Electronic security measures that are used by the association to safeguard data, including passwords, software and operating systems used by the association, which allow the changing of data, even if the owner owns a copy of that same software that's used by the association. So for example, an owner owns QuickBooks and the association owns a QuickBooks. You can't be sharing that information, notwithstanding that they have QuickBooks. All affirmative acknowledgements are part of the official records, but not accessible to the members. Again, that will be discussed later on in the presentation when we're talking about invoicing and statement methods. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, or addresses other than as provided to fulfill notice requirements. So if the information is provided, like email addresses or mailing address for notice requirements, that information is going to be accessible to the owners. Like it says here and provided in the roster, the name, unit designation, mailing address, property address, any address, email address, or fax number that's provided to fulfill the association's notice requirements. Now, an association can print and distribute to owners a directory that contains the name, unit address, and all telephone numbers of each owner. However, an owner can exclude their telephone number from the directory by written request to the association. This is not a compulsory thing, providing this directory. This is something the association can do. The association's not liable for the inadvertent disclosure of this information if it's included in an official record of the association and is voluntarily provided by an owner and not requested by the association. But again, when you're posting it on the website, you want to make sure that you're still redacting that information because there are penalties involved for willfully and knowingly disregarding the protected nature of that information. An owner can always consent in writing to the disclosure of other contact information that's not accessible to owners. Perhaps they don't have they did not provide their written consent to use electronic transmission for an association notice purposes, but want owners to be able to contact them via email. They can provide their written consent to the association to disclose the their email address. Again, with regard to website posting, the association must ensure that those records that are not accessible to owners are not posted on the association's website. And if there's information that's protected included in documents, we need to be redacting that information before we post those documents. The association's not going to be liable for disclosing protected or inaccessible information unless the disclosure was knowing or intentional. With a disregard of the protected or restricted nature of that information. The association's not going to be responsible for the use or misuse of the information that's obtained by the member or their representative in complying with the official records inspection requirements, unless the association has an affirmative duty not to disclose the information. So essentially, anything that is not accessible to unit owners, you want to be sure that you're not providing it on the website or to owners when they're doing their inspection or copying. This is a little bit more information on what is the attorney-client privilege, which we've already discussed shortly. Only the board can waive this attorney-client privilege. It's important to note that. The association's failure to provide access to the official records within 10 business days after receiving that written request creates a rebuttable presumption that the association willfully failed to comply. And damages are attached to that. The owner is entitled to actual damages or minimum damages, which are $50 per day, per calendar day for up to 10 days. The calculation beginning on that 11th business day after receipt of the request. The failure to permit the inspection entitles that person that prevails in an enforcement action to recover reasonable attorney's fees, from the person in control of the records who directly or indirectly knowingly denied access to the records. So this liability could pierce through the corporate veil directly to the director or officer. The refusal to allow the inspection or copying of an official record that is accessible to owners within the time periods required by law, which is in furtherance of any crime, is punishable as tampering with physical evidence or as obstruction of justice. Again, criminal penalties here created and woven into the Condominium Act. There are additional offenses concerning official records. Any person who knowingly or intentionally defaces accounting records that are required to be maintained or knowingly and intentionally fails to create these accounting records with the intent of causing harm to the association or one of its members, again, commits a first-degree misdemeanor subject to a civil penalty and is removed from office. We discussed this earlier. Again, a refresher, any person who willfully and knowingly refuses to release or otherwise produce records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime or to assist another person in doing so commits a third-degree felony and is removed from office. And the destruction of an official record in furtherance of any crime is punishable as tampering with physical evidence or obstruction of justice, as we mentioned before. Now, let's say a director or committee member who has resigned or is removed by recall, or their term is ending, has possession of official records. Well, that outgoing board or committee member has to return all of the official records and property of the association in their possession or under their control if it's like a electronic form of data. They had to turn over control of that to the incoming board within 5 days after the election. And an outgoing board or committee member who willfully and knowingly fail to relinquish the association's official records and property, they're subject to a civil penalty imposed by the division. Again, civil penalty, we're talking about money. And that is the end of my portion. And then Kerstin will be coming on very shortly. Thank you guys so much for having me again. I'm gonna go have a lozenge.
You have any water left in that thing? That's that was tough.
I have a little bit of coffee left.
That's good. That's good. That's good. And thank you for that. The important thing today, folks, in this complimentary session is to cover all the material in 4 hours or less. So that's why we're not going to get to a lot of the questions today, because we just want to get you certified. And before Kerstin takes over and before Danielle says her goodbyes, I do want to mention that, yes, you will have access to these slides. I'll go over that more towards the end after you fill out the evaluation. And early on, those of you who paid attention and activated the chat area, if you did that correctly, you would have seen that we placed the link in there to the website that Danielle referenced a couple of times for the condominium website on myfloridalicense.com. That's the website that Danielle referenced a couple of times. So if you can see that link, that means you are properly activated the chat area. That's where we are going to put the evaluation link later on. If you cannot see that link, press the chat button once right now so you see it. And again, I don't know how else to say this more clearly. Yes, it is going to say your chat is disabled. There is no enabling for you to do. Okay, that just means we can send the stuff one way to you. That's where we're going to send the information your way. Chat being disabled just means that you cannot chat back to us. You ask your questions in the Q&A, and if we have some time later, I know Kerstin will go over a few of them a little bit later, but certainly with a few hundred of you here today, not all of them, but we'll get to a few of them a little bit later. And one other thing, a reminder that you must be watching with your own unique link. Please don't put GRS or our firm in the awkward position of having to tell you later on that we don't see you on the registration sheet as attending. You must have, as we mentioned several times, there was a disclaimer when you entered the class that you had to check, yes, I understand, that you are here with your own link that was provided for you after registering. So please keep that in mind. Thank you, Peter. I see you.
All right. If any of you guys have any, questions, general questions concerning what was discussed, you can always feel free to send me an email, dbrennan@kbrlegal.com. I'll help you to the extent that I can. Take it away, Kerstin.
Go have some have a hot tea, Danielle. Well done. Thank you very much.
Thank you,
Have a good day.
Danielle.
All right, so let me see. Do you guys see my my screen share?
Yes, looking good.
All right, so I'm going to pick up at topic 3. Again, my name is Kerstin Henze, and I'm one of the other attorneys with the firm. All right, so we're going to be covering the levying of fines, suspension of use rights, and then financial literacy in this particular topic. So let's start with transfer fees. Okay. So transfer fees, also known as application fees, that's going to apply for those associations that have the ability to approve or disapprove sales and leases or other types of transfers, such as conveyances by quitclaim deeds. So specifically, in order for the association to charge a transfer fee or an application fee, there has to be specific authority in the governing documents, not only for the association to be able to approve or disapprove an applicant, but also to charge the specific fee in connection with the application. So the application, typically, it's provided by management, and it's an application form that the purchaser or the proposed tenant has to complete with certain information, name, address, include some references, and some additional information. And then that application is then used by the association in order to run a background check, a criminal check, as well as a financial credit check. And so this application fee is intended to cover the cost or the expense of the association running the background check. So at the moment, the application fee is capped at $150 per applicant, other than husband and wife or parent dependent child, which are considered one applicant. Okay, so as a practical tip, if you have the ability to charge an application fee in your governing documents and you have a specific amount, we typically recommend clients to, remove the specific amount and add language, basically giving the board the authority to charge a transfer fee up to the maximum amount allowed by law, as amended from time to time. This way, as this fee changes in the statute, well, you'll be able to charge an adjusted fee without having to amend your declaration. Now, if this is in connection with a lease, if the lease or sublease is a renewal of a lease or a sublease with the same lessee or sublessee, then you cannot charge an additional application fee upon renewal of that lease or sublease. Okay. Now, security deposits will apply for leases in your community. The statute allows associations to charge a security deposit in connection with the lease, provided your governing documents authorize you to do that. And if they do, you can charge up to the maximum amount of 1 month's rent, whatever the prevailing rate is in your condominium and in the area. And then you can use that security deposit to cover any damage to the common elements or association property that is caused by the tenant. Okay. If you do not have the authority to charge security deposit, then obviously there's a risk of legal challenge in doing so. And so you might want to consider then amending your governing documents to give you that authority. All right, there's another requirement in the statute for estoppel certificates. Now, estoppel certificates will come into play when an owner sells a unit in the condominium. And typically, if you've been through this process, the title company will reach out to the association and request certain information from the association or your property manager with regard to the unit and the condominium. Okay, and that is called an estoppel request, and you will be providing in response to that request an estoppel certificate. Okay, so within 10 business days of receiving a request for an estoppel, you have to respond. And the response can be provided either by a board of director of the association, a property manager, or really any other authorized agent, such as your legal counsel. Okay. Now, we've provided here a sample form of what an estoppel certificate looks like, and this comes straight from the statute. Okay, so you don't have to recreate the wheel. This is typically what you will receive from a title company, and if you don't receive a request specifically for this information, you can respond in this fashion. Okay, so it'll have the basic information such as, date of issuance, the name of the owner, unit address, etc. And then it's going to request specific information about assessments, such as what are your regular periodic assessments? When are your assessments due? Okay, are there any special assessments that owners are responsible for paying? And then certainly if a unit is delinquent on payment of any monetary obligation, this would be the opportunity that you want to disclose all of those delinquent sums so that they're paid at closing. So in addition to assessments, the estoppel certificate will also include other information such as is there a transfer fee or other fees associated with this sale purchase of the unit? So if you are authorized to charge a transfer fee, the one we just discussed, then you would disclose it in the amount. You'll also want to disclose any open violations of rules or covenants on your estoppel certificate. And that is because when the unit is sold and there are open violations, and let's take an example of an alteration that an owner may have done to their balcony, right? And it has not been addressed by the existing or selling owner. If the unit sells and you don't disclose the violation on the estoppel certificate, then the owner essentially has a defense to say, well, you didn't let me know about this open violation. I've now purchased the unit, without knowing this. And so now the association has waived the ability to come after me to enforce this violation. Okay. So you want to make sure you disclose all open violations. Now, is there a right of first refusal? That's another question you'll see on the estoppel. And you'll have to identify whether you have a right of first refusal with regard to sale of a unit. And a first right of refusal refers to, again, the ability the ability of the association to approve or disapprove purchasers in the condominium. So typically, once you receive an application and the background check, if you have the authority to approve, disapprove sales, then the board can make a business decision based on the application and the background check whether or not to approve the applicant. Okay, and you'd have a basis to disapprove for good cause, for certain negative criminal history or certain negative financial history. Now, if you disapprove for reasons other than good cause, then under Florida law, the association has to have the ability or the obligation to exercise a right of first refusal, meaning the obligation to provide an alternate purchaser that is willing to purchase the unit under the same terms and conditions as the original sales contract. Okay, so that obligation has to be in your declaration. And if you do have that obligation, you'd have to disclose that on your estoppel certificate. And then list and contact information of all other associations for which the owner is a member. This will apply if, for example, there is a master association or a POA to which the owner will become a member upon purchasing the unit. You'll have to disclose that, as well as contact information for all insurance maintained by the association. Okay. Well, the statute also authorizes the association to charge a fee for responding to these estoppel requests, okay? And at the moment, if the selling owner is not delinquent to the association, then the association can charge up to $299 for responding to the estoppel request. Now, if the owner is delinquent, then you can charge an additional fee not exceeding $179. This is in addition to the $299. Now, if the title company is requesting the estoppel information on an expedited basis, typically if there's a closing that's happening right away, then the association can charge an additional $119 for providing an expedited response, and provided that you deliver the response within 3 business days after receiving the request. Now, if the association fails to deliver the estoppel certificate within the 10 business days, and that's the normal time frame that's provided in the statute for delivering these responses to estoppel requests, then you cannot charge a fee. You'll waive the ability to charge a fee. Okay. Now, the statute also provides a fee schedule for providing responses to estoppel requests for multiple properties. most likely this will not apply to you. This is in the event that the owner owns more than 25 units, but we've provided the fee schedule here. Now, the fees that are specified in the statute will be adjusted every 5 years, and it's the Department of Business and Professional Regulations, the DBPR, that adjusts the fees every 5 years, and it's going to be based on an annual increase for the 5-year period based on the Consumer Price Index. And when the fees are adjusted, they will publish the new fees. Okay, now the estoppel certificates can be delivered by mail, by email, as well as hand delivery. And if they are delivered by hand delivery or by email, then they are effective for 30 days, not years, 30 days. If you respond to an estoppel certificate by mail, then they're going to be good for 35 days. Okay. Now, the association cannot charge for an amended estoppel certificate, right? So if there's anything that needs to be amended, you cannot charge a new fee. But you can charge a fee for providing a new estoppel certificate if it's going to be issued after the previous estoppel certificate expires. So this could occur, for example, if the closing date was postponed beyond the period of the effective date of the estoppel. And so in that case, if you have to issue a new estoppel certificate, then you can charge a new fee. Now, there could be circumstances under which typically this will happen with a lien holder mortgage company, whereby the selling owner, the mortgage company will request additional information from the association. If that occurs, the association can charge a reasonable fee to the purchaser, the lien holder, or the current parcel owner for providing good faith responses to these requests, as long as the fee does not exceed $150, plus the reasonable cost of photocopying and any attorney's fees. So if you do, if the board does need to seek legal guidance in responding to any specific inquiry, then yes, you can charge your attorney's fees in response to that request. Now, in accordance with the statute, the association and its authorized agents who are providing these responses, they're not liable for providing the information in good faith pursuant to a written request if you include this disclosure that's here at the bottom of the slide. The disclosure basically says the responses herein are made in good faith and to the best of my ability as to the accuracy. Okay, so make sure that whoever responds to a request for additional information includes this disclosure. All right, there are other documents that the association has to maintain, and one of them is a condominium question and answer sheet. Okay, that is also typically provided at the time of sale. So the association has to update annually and must be provided to the prospective purchasers by the association. A question and answer sheet is typically 1 page, and you can download this form from the Division of Condominium website. Just Google Division of Condominium. And it's going to have a set of questions regarding the condominium association, such as, are you allowed to lease in your community? What are some of the use restrictions? What are your assessments? Is there a recreational land lease that you have to pay? Are there any current pending litigation matters that exceed $100,000? And so the association has to respond to these questions and annually revisit them and make sure that you make any changes to your answers as needed. And then you maintain this question and answer sheet as part of your official records. Okay, and then obviously as noted here on the slide, then you have to provide a copy of the Q&A to a prospective purchaser. And then the seller also has a duty to provide the buyer notice of all hidden defect. That's obviously on the selling owner, not on the association. All right, let's move on to fines and suspensions. All right, so the first slide, the first few slides are going to address the ability to fine and suspend use rights when an owner is in violation of your governing documents or rules, okay? The authority to fine is already provided in the statute. So the statute already says that the association can fine an owner, including their guests, their occupants, their licensees, their invitees, as well as suspend their use rights to certain common facilities if they're in violation of your covenants and rules. So you don't necessarily have to go ahead and amend your documents to give you that authority. If you are already amending the documents, it's not a bad idea to include it, but you don't have to. All right. The ability, so the basic process for fining an owner and suspending an owner's use rights for covenant violations is what I call a two-step process. Okay, so the first process is whereby the board adopts the fine or the suspension of use rights at a duly noticed board meeting, and we'll talk about what the notice requirements are in the later slides. And then once the board adopts the fine or suspension, neither the fine nor the suspension can be imposed unless the violating individual goes or has the opportunity to go before a committee, and you can call it the fining committee, the suspension committee, the grievance committee, whatever you call it. But that committee has to, you have to provide notice of that committee hearing to the violator at least 14 days before the date of that committee hearing. Okay, and if you do not follow this process, if you do not give the violator the opportunity to go before this committee hearing with at least 14-day notice, then the fine or suspension can be successfully challenged by the violator. Okay. Now, the hearing has to be held before an impartial committee of at least 3 individuals. And the role of the committee is really not to negotiate the fine or really to even discuss the basis of the violation. I mean, certainly the committee is going to hear the arguments presented by the violator. But really the role of the committee is simply to either confirm the vote of the board and impose the fine or suspension, or reject the fine or suspension imposed by the board. Okay, it's a yes or no vote, nothing else. They're not there to reduce the fine or anything else. Okay, and if the committee does not confirm the fine or suspension, then it cannot be imposed. Now, the impartial committee has to consist of at least 3 members who are not officers, not directors or employees of the association, or the spouse, parent, child, sibling of an officer, director, or employee. Now, I recognize that for some of your associations, if you might not have you're probably small and might not have individuals who are not officers, directors, employees, or otherwise residing with any of them. And so for you, for your community, this might not necessarily be a viable option. And that's okay. I mean, fining and suspending use rights is just one of many other remedies that the association has to enforce a covenant violation or rule violation. And we actually do have, we do teach webinars on covenant enforcement. Okay, so, if you're interested in exploring what your remedies are, we do offer this webinar. But again, fining is just one remedy. So now, under current Florida statute, the fine cannot exceed $100 per violation. And each day that the violation remains uncorrected, you can fine of $100 for each day, up to a maximum of $1,000 in the aggregate. Okay. Now with condominiums, the fine cannot become a lien against the unit, and it's due 5 days after the date of the committee meeting at which the fine is approved. So that means that if the violator doesn't pay the fine voluntarily, to a maximum of $1,000 in the aggregate, well, you can't then impose, you can't assess that fine against the unit and then, try to recover it through the collection process and recording a claim of lien and then foreclosure. Okay, that's at the moment, the current state of the law is you cannot recover it this way. Okay, you do have the option of recovering that fine through small claims court. In our experience, most clients do not try to do that because, I mean, the filing fee to file a complaint in small claims court, it's, just under $500. So that's, that's basically half the cost of the fine. So you can leave the fine reflected on your account ledger, and certainly when the unit sells, reflected on the estoppel certificate, and then hopefully you'll be able to get it paid at closing. Okay. Now, under the statute, associations also have the ability to suspend use rights if the owner becomes delinquent in a monetary obligation to the association and remains delinquent for more than 90 days. Now, we'll talk about the specifics of what areas of the condominium you can suspend use rights. But for suspending use rights for delinquencies on monetary obligations owed to the associations, that only requires a board vote. So you don't have to have that committee hearing that we just talked about for fining and then suspending use rights for covenant violation. So it's just a board vote. You notice the meeting at which you're going to suspend use rights for delinquency at least 48 hours in advance with your designated agenda, and then you take your vote at the meeting. Now, the use right suspension will become effective until the monetary obligation is paid in full. And monetary obligation can include not only regular or any special assessments, but certainly any interest, any late fees, and certainly attorney's fees that you've incurred in any collection action. Let me see, did I skip a... Now, the suspension of use rights typically will apply to facilities to which you can control access to, right? So typically would be your pool, your clubhouse, if you have a library, if you have a media center, your gym, those types of facilities. If you have the ability to deactivate a fob, for instance, this is one way that you could suspend use rights to those facilities. Now, the statute is very clear that it does not apply to certain areas of the condominium, such as limited common elements intended to be used only by that unit. So, for example, you wouldn't be able to suspend an owner's ability to use the balcony if that's considered a limited common element under your declaration, or to the common elements needed to access the unit, utility services provided to the unit, parking spaces, or elevators. So I know, for example, with some certain high-rise elevators, you need a fob in order to be able to go to your designated floor. You would not be able to deactivate the fob in order for the owner to use the elevator. Okay, so you have to allow the owner to use elevators and then park in their designated parking space. Now, the association also has the ability to suspend voting rights if the owner is delinquent on a monetary obligation to the association for more than 90 days. In order to suspend voting rights, the delinquency does have to be greater than $1,000, and then proof of the obligation must also be provided to the owner 30 days before the suspension takes effect. Presumably, if the owner is delinquent on any monetary obligation to the associations, which typically includes assessments, you would have already sent some kind of delinquency notice to the owner to pay. So that could serve as your 30-day notice here for suspending voting rights. Now, while the ability to suspend use rights and fine and impose fines for covenant violation doesn't have to be specifically in your declaration, there has been recent case law that has come out that essentially suggests that in order to suspend voting rights, you have to either have express authority to suspend voting rights in your declaration, or you have to have Kaufman language in your declaration. Kaufman language, it's a little bit beyond the scope here, but Kaufman language refers to the magic words as amended from time to time, which typically can be found after reference to Chapter 718 of the Florida statute. That is referenced in your declaration. So what that means is that if you have Kaufman language, if your declaration says that your association is subject to 718 as amended from time to time, then substantive changes to the Florida statute that affect vested rights of owners will retroactively apply to your community. And so you'd be subject to the new changes in the law. So you either have to have Kaufman, or you needed to have amended your declaration to specifically authorize you to suspend voting rights. That's what this case suggests. So in an abundance of caution, if you want to be able to suspend voting rights, then speak with your legal counsel about amending your declaration to give you that authority. Now, if you do properly suspend voting rights, and that is done at a duly noticed board meeting, you don't need a committee hearing for that. Presumably you have the authority and you've properly suspended voting rights, then the effect that this has is that the unit that was suspended would not be counted towards the quorum requirement or towards the voting percentage that you need to obtain in order to pass a particular action that requires a membership vote. So, for example, if you're looking to amend your governing documents, many communities have found it helpful to suspend voting rights of delinquent owners, okay, to sort of reduce the voting percentage that the association needs to pass an amendment. So if you have, for example, a condominium that has 100 units, and let's say your quorum requirement is a majority of the 100 units, that's 50% plus one, and you've suspended the voting rights of, let's say, 10 owners, then your quorum is going to be based on majority of the 90, not a majority of the 100. And then if you needed to approve, in order to approve an amendment to your declaration, let's say you needed a vote of, 2/3 of the membership, well, again, it would be 2/3 of the 90, not 2/3 of the 100 units. All right. So let's shift gears to budgets, reserves, and financial reporting. So every year, the board has to prepare and adopt an annual budget, which must include estimated revenues, operating costs, and reserves for the upcoming fiscal year, right? So we've included here on the slide some of the basic operating line items that you might find in an association budget, and certainly you might have more than that, but typically your operating expenses will include administration, management fees if you have a property manager, assist with management and operations, certainly maintenance and repairs, rent, if you have a recreation lease, taxes, insurance, professional expenses, if you have legal counsel or engineers or an accountant, that would be included in your operating budget. Now, with regard to adopting the budget for the association, typically the budget is adopted by the board at a properly noticed board meeting. Unless your documents provide for a greater notice requirement, typically the notice of the meeting at which the board will be adopting the budget has to be provided to the owners at least 14 days prior to the meeting. Okay, and it can be sent by mail, by hand delivery, or electronically transmitted, meaning via email or via fax to those owners who have consented to receiving notices electronically. In addition to providing notice of your budget meeting, you're also going to enclose a copy of your proposed budget with the notice. Okay. The person providing the notice of the meeting must then execute an affidavit of mailing evidencing compliance. And then if the board makes any changes to the budget during a properly noticed board meeting, you do not need to resend or renotice the budget meeting notice. So if at the budget meeting you're crunching the numbers or you've received some new information about certain expenses and you have to adjust your numbers, that's okay. I mean, you can adopt a budget with the revised numbers at that meeting without having to renotice your meeting or provide a new budget to the owners. Now, effective July 1st of 2021, the board is required to adopt the annual budget at least 14 days prior to the start of the association's fiscal year. So your bylaws will typically indicate when your fiscal year starts, whether or not it's a calendar year. So whatever that is, you have to, under the statute, adopt your budget at least 14 days prior to that. Now, you might have a provision that says you have to adopt the budget at least 30 days prior, and that's okay. And then you'll go with whatever's in your bylaws, okay? Now, the statute also says that in the event the board fails to timely adopt the annual budget a second time, that is deemed a minor violation, and the prior year's budget continues in effect until the new budget is adopted. All right, let's talk about reserves. So Danielle talked about your CEUs reserves, okay? We're gonna talk about reserves in general, okay? Which the requirement remains for all condominiums, whether you're 3 stories above or under, you still have a statutory requirement to maintain reserves for the following items, right? Your roof replacement, building painting, pavement resurfacing, and then any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. Now, on the previous slide, we've provided definitions of what a capital expenditure or deferred maintenance expense is, and given some examples. So, for example, your CEUs, if you're subject to the CEUs, whether or not it includes, for example, elevators or, seawall restoration, that's a discussion you need to have with an engineer. But presuming that your CEUs did not include seawall replacement and you do have a seawall, well, that would typically fall under the non-CEUs reserves. Okay, so you're still going to be maintaining some level of reserves. Computing reserves, well, the amount to be reserved must be computed using a formula that's going to be, you're going to be, hopefully you've had your reserve study specialist review your reserve assets, your reserve items, and then They've provided you with the formula that's going to be based on the remaining useful life and the estimated replacement cost or deferred maintenance expense of that of each reserve item. So unless the association maintains pooled reserve accounts, your schedule is going to include the bullet points that we've identified here, right? So you're going to include the total estimated useful life of every asset, the estimated remaining useful life of the asset, the replacement cost, and then the estimated fund balance as of the beginning of the period for which the budget will be in effect. So your budget is going to really have two sections. You're going to have an operating section of the budget, and then you're going to have a reserve schedule that's going to be attached with your budget, right? And then that reserve schedule is going to include these items here that we've identified. Hopefully you have a CPA, an accountant that you are working with, and that accountant knows the requirements of budget and reserves for condominium associations, and then can assist you with creating these budgets, or you have a management company that can assist you with that. Okay, waiving and reducing reserves. So this is only permitted for non-structural reserves, for non-SERS reserves. Okay, that is still allowed. So we're talking about non-SERS reserves. The obligation of the board every year is to fully fund your reserves, right? However, the statute does allow boards to give owners the option of whether or not to waive reserves every year or to partially fund them. Now, whether or not you want to give owners the option to waive or partially fund non-SERS reserves, that is completely within the discretion of the board. You're not required to do that, okay? But if you give owners the option to waive or partially fund reserves, the statute says that the vote that you need to get is the vote of the majority of the voting interest. It used to be that you needed to get the approval of a majority of the voting interest at a meeting at which a quorum is established. So that's a much lower threshold. Well, that threshold has been increased now to just a majority of the voting interest. The vote to waive or reduce reserves, if you do get that vote, is only applicable for the budget year that the vote was taken. Okay, that means that every year you have to fully fund unless every year you give the owners the option to waive or reduce reserves. Now, as a practical tip, you can have the membership meeting at which the owners will vote on either waiving or reducing reserves. You can have that membership meeting on the same date that the board adopts the budget, right? Just make sure that you have your membership meeting first, and then have your budget meeting, your board meeting at which you can adopt the budget following that membership meeting. That way you'll know at that point what was the decision of the owners, right? And that way you can adopt the appropriate budget, either the budget with fully funded reserves or the budget with the waived or reduced reserves. Another practical tip is, don't give the owners both options to waive or reduce reserves on the same ballot or limited proxy, right? Because you need a vote of the majority of the voting interest. So if you give the owners both options on the same proxy or ballot form, then obviously your chances of getting the vote that you need are greatly reduced. So you as a board need to come up with a decision as to whether or not you even want to give the owners either of these options. And if you do, which option you want to give. So choose one option and then present to the owners the vote that that you want, that you want to give the owners the opportunity to vote on. Okay, and if at the meeting you do not get the vote that you need, then reserves, fully funded reserves go into effect. Now, authorized uses, reserve funds, and any interest that's accruing on these reserve funds, they can only be used for the purpose for which they were designated, right? So if you have a reserve account for elevator modernization, then those funds can only be used in connection with those elevators, right? They cannot be used for building painting. Unless, of course, you get the membership approval to use those reserve funds for alternate purposes. And if you do present this option to the owners, then the vote that you need to get is a vote of the majority of the voting interest. Okay. It used to be that you also needed to get a vote of majority of quorum, but again, this was a statutory change a couple of years ago, so it's making it increasingly more difficult for boards to get membership vote in connection with reserve funds. As Danielle mentioned, with regard to the CEUs reserves, you no longer have the option to use CEUs reserves for alternate purposes. So this is only in connection with non-CEUs reserves. Pooling, if you currently do not pool reserves, if you have straight line accounting for your reserve items and you want to pool reserves, for 2 or more reserve items, then you need to get a vote of the owners, and you'll need to get the approval of a majority of the voting interest. Now, for any ballot or limited proxy that you submit to the membership in connection with the waiver or partial funding of reserves, or in connection with use of reserve funds for alternate purposes, the statute requires you to include this disclosure that's here in bold face at the bottom of the slide. So your limited proxy in your ballot has to include this disclosure saying that waiving of reserves in whole or in part, or allowing alternate uses of existing reserves, may result in unit owner liability for payment of unanticipated special assessments regarding these items. All right, we talked about budgets. So now we're going to talk about financial reports. So every year, within 90 days after the end of your fiscal year, whichever date that your bylaws provide, or annually on a date provided in the bylaws, the association shall prepare and complete a financial report of the preceding fiscal year. Then within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the association must mail or hand deliver to each unit owner a copy of the financial report, and the statute says now, and a notice that a copy of the most recent financial report will be mailed or hand delivered to the unit owner without charge within 5 business days upon receipt of a written request from the unit owner. So the statute used to say that you had the option to either mail or hand deliver a copy of your financial report, or give them notice that the financial report was completed and it will be made available free of charge upon the owner's request. For some reason, the statute now says and. So hopefully this is corrected in this year's legislative session, and the word or is put back in the statute, because otherwise this makes no sense. All right, those were the the time frames for preparing and providing copies of the financial report. Now, your financial report, the level of the financial reporting is going to be based on your annual revenue. So the statute, for example, provides that if your total annual revenue is 150,000 or more, but less than 300,000, then you only have to prepare compiled financial statements. Okay, so under the statute, if your annual revenue is $500,000 or more, then you are required to prepare audited financial statements. unless, of course, your bylaws already include a requirement for you to do a financial audit. So if your annual revenue falls under 500,000, but your bylaws say that you have to prepare financial audit, then you have to prepare financial audit unless you amend that provision in your bylaws to remove that requirement. If your bylaws are silent about the requirement to do a financial audit, then you would only be required to do an audit if your annual revenue falls within this threshold that's in the statute, okay? Now, one of the laws that took effect on July 1st of 2024 is that, members can vote to reduce the level of financial reporting, regardless of what your annual revenue is. The membership can always vote to reduce the level of financial reporting, but the new law now states that you cannot do so for consecutive fiscal years. All right. So that was it for topic 3. Moving on to topic 4, we're going to cover notice meeting requirements, insurance requirements, and then conflicts of interest. And then we should be done. All right. Meeting notices. We're going to talk about membership meetings. So the first the first thing I want to just quickly cover is the distinction between board and membership, right? So sometimes boards will say we're having an association meeting, right? Well, I don't know what an association meeting is. It's either a meeting of the board of directors or it's a meeting of the membership, of the owners. A meeting of the board of directors is a meeting at which the board votes. A meeting of the membership is a meeting at which the owners vote. Okay, so if you're just going to give reports to the owners, that doesn't necessarily have to be noticed as a membership meeting because owners are not voting. You're just reporting to the owners the state of the condominium, right? So that would be typically a board meeting. Okay. What we're going to talk about here is membership meetings, meetings at which owners vote. And under that big umbrella, there are 2 types of membership meetings. There is the annual membership meeting, and then there's special membership meetings. So if nothing else, the one and only meeting that most associations have and that you are required to have is your annual members meeting. Right? And that is the meeting at which your election will be conducted. Okay. Any other membership meeting at which owners vote other than your annual meeting, it's going to be called a special members or a special membership meeting. Okay. The location of where your annual or really your special membership meeting is going to take place is going to depend on what your bylaws say. Okay. What we typically recommend is that you amend your bylaws to give the board the discretion to set the date, the time, and then the location of the meeting. Okay. If the bylaws are silent as to your location, the meeting must be held within 45 miles of the condominium. Membership meetings may need to be held at a location accessible to physically handicapped persons if it is requested by a physically handicapped person. Now, the bylaws must provide the method of calling meetings of the unit owners, including annual meetings. And as I already mentioned, your election will occur on the date of the annual meeting. Now, with regard to special membership meetings, when called by the board or upon written request of at least 10% of the unit owners, you have to call a special membership meeting unless, of course, there's a different percentage provided in your governing documents. Okay, so if you receive a petition from at least 10% of the unit owners requiring the board to call a membership meeting, it could be for, many reasons, such as, wanting to amend your governing documents, then you got to call that membership meeting. Notices must include an agenda, right? All the agenda items that you'll be taken on at the meeting, and has to be either mailed, hand-delivered, or electronically transmitted to each owner at least 14 days before the meeting, as well as posted on condominium property at least 14 days prior to the meeting. Now, if your bylaws provide for a greater time frame, then you go with that. Otherwise, the minimum notice requirement is 14 days. The board has to adopt by rule, must by adopted rule designate a specific location on the condominium or association property at which members' meeting notices are posted. Okay. Notice must be mailed. If you are mailing notice of membership meetings, it has to be mailed to each owner at the address that's last furnished to the association by the unit owner. Proof of notice has to be provided by affidavit. Okay. And unless a unit owner waives in writing the right to receive notice at the annual meeting, such notice must be hand-delivered, mailed, or electronically transmitted to each unit owner. Now, in lieu of or in addition to the physical posting, the association may adopt a procedure for posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system serving the association. So if you have a bulk service agreement and you have this option, you have this cable television, a closed circuit system, then you have the option to broadcast the notice. Okay, electronic notices. Already mentioned this several times, but one of the ways that official notices of the association can be delivered to owners is by electronic transmission, which includes email or fax. Not sure if anybody has a fax these days. Email seems to be the most viable option. But again, in order for the association to use email for official notices of the association, the owner has to consent to receiving notices electronically. The consent has to be done in writing, okay? They can send their consent electronically as well, okay? But if an owner does not consent to receiving notices electronically, okay, then while you can email them notice as a courtesy, you'll have to still either mail or hand deliver the official notice of the meeting.
Just a quick anecdote so you can have a swig of water, because I'm sure your voice needs it. When you mentioned fax, it just reminded me that over the weekend, my granddaughter said, what's a fax? So anyway, I'm at that point in my life. Back to you.
The association is required to maintain email address and fax numbers for those owners who have consented to receiving notices electronically. The big takeaway here is that if owners do consent to receiving notices electronically, then those email addresses and fax numbers do become accessible to other owners. So if you have an owner that's requesting to inspect association records, or is requested to obtain a copy of the owner roster to include email addresses, then you'll be forced to disclose those email addresses for those owners who have consented to receiving notices electronically. Okay, and then for those associations who manage condominiums with 150 or more units, you also have an obligation to post copies of notices on your website. as Danielle mentioned, that threshold requirement was amended in the effective July 1st of 2024. So starting January 1st of 2026, condominiums with 25 or more units will be required to have websites. But for the moment, those that have 150 units or more, you have to post notices of all membership meetings at least 14 days prior to the meeting. And then you also have to post on your website any document that is associated with that membership meeting. So, for example, if you are having owners vote on amendments to your governing documents, well, you have to post a copy of those amendments on the website. If you currently are not required to maintain a website because you have less than 150 units in your condominium, but you maintain a website, you do have the option to post notice on your website as well. For quorum at membership meetings, we're still with membership meetings, unless there's a lower number provided in the bylaws. Your quorum requirement is going to be at least a majority of the voting interest. Okay. And then unless otherwise provided in the Florida statute or in your governing documents, decisions made by members must be made by a majority of the voting interest represented at a meeting at which a quorum is present. So let's say your declaration requires the approval of 2/3 of the owners to amend the declaration. Well, then you go with the 2/3 vote on any amendment to your declaration. Other than that, you'd require a vote of the majority of the voting interest represented at a meeting at which a quorum is present. So what that means is, let's say your condominium has 100 units. And let's say the minimum number of owners that showed up was quorum, which is a majority. So 50% plus 1, so 51 owners. So a majority of quorum would mean that at least a majority of the 51 need to vote affirmatively in favor of the particular action that you want owners to vote on in order for it to pass. Okay. Now, in addition to voting at membership meetings, there is an option for owners to vote via a written consent. A written consent is very similar to a limited proxy, but the written consent process serves in lieu of having a membership meeting. So rather than noticing a membership meeting, you would provide owners with a memorandum or some kind of cover letter indicating the action that you want owners to take, what they need to vote on. And then at the bottom of the form, you would include a signature line for those owners who are consenting to the specific action to sign and return the consent form. Okay. So in order to be able to obtain a vote of the owners via the written consent process, you have to have specific authority in your documents. Okay, typically you'll find that in your bylaws. And then if you do, the written consent forms are, they're good, they're effective for 90 days from the date of the first executed consent form. So very similar to a limited proxy. Which means you have up to 90 days to get the consent forms that you need in order for the action to pass. Okay. Obviously, if you don't get the consent forms that you need within the time frame, the issue dies, and then you would have to restart the process again. Okay. So if you want to have this this option, the ability for owners to vote or approve action by written consent, check your bylaws, and if you don't have that specific authority, then, consult with legal counsel about amending your documents. All right, member participation. Owners do have the right to speak at membership meetings with regard to all agenda items. And if you don't already have rules, certainly recommend the association to adopt rules governing the frequency, duration, and manner of member statements. Now, members also have the right to record or videotape meetings subject to reasonable rules adopted by the division. So we've included those here, and they come straight from the Florida Administrative Code. So you can take a look at this at your convenience. Voting by proxy. So there are two types of proxies that can be used in connection with membership meetings. A general proxy and a limited proxy. Now, both can be used to establish quorum. Typically, a general proxy could be used, and where it's typically used is in connection with an annual meeting for issues other than elections, right? So as Danielle may have mentioned, you don't need quorum in order to conduct your election, but you do need quorum in order to conduct your annual meeting. So general proxy would typically be sent out in connection with your annual meeting and the election ballots. Now, limited proxy is what will typically be sent out to owners in connection with a specific action that you want owners to vote. And in fact, the statute says that limited proxies must be used in connection with certain votes, such as vote taken to waive or reduce reserves, votes taken to waive the financial reporting requirement, and then votes taken to amend the declaration. And then there's, and other votes that you would need to use the limited proxies. But essentially, proxies are good and effective for 90 days after the date of the first meeting for which it was given. So what that means is that, let's say you have a membership meeting, May 1st in order to amend your declaration. And let's say May 1st comes around and you don't have the necessary votes at that meeting. Well, there is a process by which you can recess and reconvene that meeting as many times as necessary up to that 90th day in order to then go and, collect the votes that you need. Okay, so if you're in that situation, speak with your legal counsel about properly recessing and reconvening the meeting. Because once you adjourn the meeting, then that's it. The meeting ends, the action dies, and then if you didn't get the votes you need, you'd have to basically restart. Okay, and then proxies are revocable at any time at the pleasure of the member executing it. All right, so we talked about membership meetings. Let's talk about board of director meetings. So officers and directors have a fiduciary responsibility to the unit owners and must act reasonably. Okay, you don't have to be right every time, but you have to exercise reasonable business judgment to make decisions. And yes, you're not expected to know everything about condominium law. You have to rely and should rely on the experts, on your legal counsels, on the engineers, on your accountants, on your property manager. The board must exercise its best efforts to purchase insurance, rely on advice and guidance of your experts, etc. Directors must not be compensated unless otherwise authorized in your bylaws, unless it's for work performed in one straight with all the conflict of interest disclosures being properly made. And we'll talk about conflicts of interest in a minute. So unless your documents provide otherwise, director should not be compensated for services provided as a director. Now, unless otherwise provided in your governing documents, the corporate powers of the corporation are exercised by the board, which means that the board makes decisions, the board votes and takes actions unless there's specific issues that require a membership vote. No board member, not even the president, should make unilateral decisions unless, of course, their power is delegated typically via resolution, or it's an emergency situation. And then the board is generally responsible for the maintenance and operations of the association, including health, safety, and welfare. All right, kickbacks. This was added in the statute recently. So an officer, director, or manager may not solicit or offer to accept a kickback. And a kickback is now defined in the statute, which means anything or service of value for which consideration has not been provided for an officer, director's, or manager's own benefit or that of their immediate family from any person providing or proposing to provide goods or services to the association. So, if an officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback, they now commit a felony of the 3rd degree and is subject to civil penalties as well as removal from office. There is, however, no prohibition in the statute against an officer, director, or manager accepting services or items received in connection with trade fairs or education programs. So typically, every so many times throughout the year, there are these trade expos where vendors that provide services in this industry, they set up a little booth and have little knickknacks. And so board members and managers walk around and speak to vendors and, obtain goodies. That is acceptable. That is not a kickback.
That means that if I see you and recognize you at a trade show and I try to hit you with one of the stress balls with the firm logo on it, that is not considered a kickback. Correct.
Correct.
All right.
All right. One of the changes that took effect July 1st of 2024, an association and its officers, directors, employees, and agents may not use a debit card issued in the name of the association. And then a person who uses a debit card issued in the name of the association for any expense that is not a lawful obligation of the association now commits theft and must be removed from office. We'll talk about fidelity bonding momentarily, but you definitely want to make sure you have fidelity bonding to protect against embezzlement of association funds by directors or officers, or really anyone who handles association funds. A director or officer who is charged by information or indictment with any of the following crimes must be removed from office. And those include forgery of a ballot envelope, voting certificate used in condominium elections, theft or embezzlement involving association funds or property, destruction of or refusal to allow inspection or copying of an official record of the association, which is accessible to unit owners within the time frame provided by law, obstruction of justice, and then any other criminal violation under the Condominium Act. And the board must fill the vacancy until the end of the suspension period or end of the director's officer's term, whichever occurs first. And then a director or officer who has such charges pending may not be appointed or elected to a position as a director or officer of any association and may not have access to the official records except pursuant to a court order. So, some of the ways to get off the board, if you're looking to get off the board, well, you can certainly resign in writing. Owners can also recall directors, and there is a recall process in the statute that we're not going to discuss here, but it is in the statute. If a director is delinquent in the payment of any monetary obligation due to the association for greater than 90 days, well, then you are deemed to have abandoned your seat, creating a vacancy. And a monetary obligation, again, can include any regular special assessments, interest, administrative late fees, and attorney's fees. Criminal charges involving theft or embezzlement of association funds or property will certainly get you kicked off the board. And then for a knowing and willing violation of the Condominium Act, the division may order removal of the officer or director. And then failure to satisfy certification requirements, you will be suspended until you comply with certification requirements, which is why you're here today. Now, effective July 1st of 2024, in a residential condominium association of more than 10 units, the board must meet now at least once each quarter, so at least 4 times a year. And then at least 4 times each year, the meeting agenda must include an opportunity for members to ask questions of the board. There is no statutory requirement for the board to answer those questions at the meeting, but you do have to allow owners to ask the questions. At times, the board may take action outside of the context of a properly noticed board meeting. Typically, if there are emergencies, if that occurs, you would need to ratify the board action, and the law allows ratification at the next properly noticed meeting. Board members can use email as means of communication, so you can email each other. You just cannot use email to cast a vote. So you cannot vote technically by email. Generally, in terms of noticing board meetings, unless your bylaws provide something else, typically you would only need to post notice of the board meeting on condominium or association property at least 48 hours prior to the meeting, unless it's an emergency, right? And then you'll have to ratify the action at the next duly noticed board meeting. Now, the statute does provide for 2 types of meetings that do require at least a 14-day notice. Now, if your bylaws provide for a greater time frame for noticing these meetings, then you obviously have to go with your bylaws requirement. But otherwise, it's at least a 14-day notice for any board meeting at which the board is going to adopt a non-emergency special assessment or an amendment to rules regarding unit use. So for example, if you're going to be adopting architectural specifications or standards about alterations to units that affect unit use, and you would need to notice the board meeting at which you're going to adopt these specifications at least 14 days prior to the meeting. And then you have to evidence compliance with this notice requirement by signing an affidavit. Other than that, it is a 48-hour notice unless your bylaws provide for something greater. The board must designate a specific location on condominium property at which all notices will be posted. And if there is no condominium property at which notices can be posted, then notices must be mail delivered or electronically transmitted to each owner at least 14 days before the meeting. And then again, for those condominiums that do have a bulk cable contract and have a closed circuit cable television system, you also have the option to post notices in this fashion. Again, for those condominiums that currently maintain websites, if you're required to maintain websites, you also have to post notices of your board meetings, either 48 hours prior or 14 days prior to the meeting. And then you also have to post any documents that are associated with that board meeting on that website. So for example, if the board is looking to adopt the contract, a copy of the contract would also need to be posted on the website. For those condominiums that have less than 150 units, but you still maintain a website, then it's a good idea for you to also post notice, and you can post notice on your website. As with membership meeting notices, board meeting notices must also specifically identify all agenda items. Now, an item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus one of the board members. So if you've posted your notice with all your agenda items and, you know, some issue comes up on on an emergency basis at that meeting for which you did not previously include on the agenda, you can take it up at the board meeting by a vote of the majority plus one of those who are there at the meeting. But then importantly, you have to still ratify that decision at the next board meeting, okay? If 20% of the voting interest petitions the board to address an item of business, then the board, within 60 days after receiving the petition, must place that item on the agenda at the next regular board meeting or special board meeting. Effective July 1st of 2024, if an agenda item relates to the approval of a contract for goods or services, then a copy of the contract must be provided with the notice, and then also has to be made available for inspection and copying upon written request from an owner. So if you are going to approve a particular contract at a board meeting that only requires 48-hour notice, then that means that, yes, you're going to have to figure out a way to post a copy of that contract. A small contract, not a big deal, but if you've just, you're about to enter into an AIA construction contract that's about 60 pages long, that could be a bit, burdensome. So, but those are the new requirements effective July 1st. If you're going to adopt a special assessment, then the statute says that notice of the meeting at which you can adopt the special assessment has to also include the purpose of the special assessment, the description, and then also the estimated cost of the assessment. Meetings of the board at which a quorum of the board is present have to be open to all unit owners, except for meetings between the board and association attorney with respect to proposed or pending litigation, or meetings held for purpose of discussing personnel matters. And just like with membership meetings, owners also have the right to tape record and videotape meetings of the board of directors, subject to rules of the division, which we've included them here as well. Effective July 1st of 2024, owners have the right to attend board meetings. And the owner's right to attend board meetings includes the right to speak at meetings with reference to all designated agenda items and the right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. If you have not done so already, we encourage you to adopt rules governing the frequency, duration, and manner of member statements, which the statute allows you to do. A majority of the board present at a board meeting is what constitutes a quorum. Yes, directors can meet by telephone conference, okay? And those board members attending by telephone may be counted towards quorum and can vote via telephone. Board members can also appear and vote at board meetings via video conference or similar real-time electronic or video communication, such as, via Zoom, as long as everybody else in the room can hear the director. And their appearance electronically will count towards quorum. Unless otherwise provided in the Florida statutes or in your governing documents, the action of a majority of the directors present at a meeting at which a quorum has been attained constitutes the action of the board. Now, directors cannot vote by proxy or by secret ballot at board meetings, with the one and only exception that they can vote by secret ballot when appointing or electing officers. And by that, I mean, you can literally use a Post-it to cast a vote for an officer. Now, committee meetings. If the meeting of the committee is to either take final action on behalf of the board or make recommendations to the board regarding association budget, these meetings are always going to be subject to meeting notice requirements and cannot be exempted. So you'd have to adopt your these meetings with in accordance with the statute, right? At least 14-day notice. Now, if it's a meeting of a committee that either does not take final action on behalf of the board or makes recommendations to the board regarding association's budget, then those meetings can be exempted from the notice requirement only if they're exempted in the association bylaws. So it's you can adopt an amendment to the bylaws to exempt these types of committee meetings from the typical notice requirement. Otherwise, you would still have to notice these committee meetings as you would any board of director meetings with either 48 or 14-day notice. All right, we're getting very close to the end. I think we only have insurance and conflicts of interest, and then we're almost done. So I'm going to try to get this done in the next 15-20 minutes to leave some time for questions. All right, so residential condominium associations have to use best efforts to obtain and maintain adequate insurance to protect the association property, the common elements, and the condominium. Now, what it means to maintain adequate property insurance, well, that is going to depend and be based on the replacement cost of the property as determined by an independent insurance appraisal or updated appraisal. And that appraisal has to be done at least once every 36 months. Now, in addition to your property insurance, the association should also have liability insurance for directors and officers. That's your D&O coverage, which provides coverage in the event of errors and omissions, negligence of board of directors and officers. And then whether or not you need to maintain flood insurance, well, that's going to depend on where you're located. So certainly recommend that you speak with your insurance agent regarding all your insurance needs. You're also required to maintain what is known as fidelity bond or fidelity insurance coverage for all persons who control or disperse funds, association funds. And the term persons who control or disperse association funds includes, but not limited to, those individuals who are authorized to sign checks, as well as, the president, secretary, treasurer, and, your management team if you are managed by a management firm. The fidelity bond insurance must cover the maximum funds that will be in custody of the association or its management agent at any one time. And unlike for HOAs governed under Chapter 720, who have the ability to waive this requirement by vote of the owners, condominiums do not have this ability. So you are required to maintain fidelity bond coverage. The cost of the coverage is an association common expense. Effective July 1st of 2024, if the division receives a complaint, the division will monitor an association for compliance with the statutory insurance requirements and may issue fines and penalties established by the division for failure of an association to maintain the required insurance policy or fidelity bond. Now, what type of coverage you're required to maintain? Well, for any property insurance issued or renewed on or after January 1st of 2009, you have to have primary coverage for all portions of condominium property as originally installed or replacement of like kind and quality, as well as all alterations and additions made to the condominium property. Exclusions from association coverage are the unit owner's responsibility. We'll talk here in the slide what they are. So association coverage must exclude all personal property within the unit or limited common elements, and that includes your floor, wall, and ceiling coverings, appliances, water heaters, water filters, built-in cabinets, countertops, including drapes and blinds and any other kind of window treatment or replacement of these items. Okay, so these specific items are excluded from association coverage and are the responsibility of the unit owners to maintain insurance. Now, effective July 1st of 2010, the ability to force place owners coverage requirement was eliminated. So that means that there's nothing in the Florida statute that currently requires owners to maintain insurance coverage for these items. So if the board wants to require owners to maintain insurance, the only way to compel that requirement is to amend your declaration to force owners to purchase insurance. Now, whether or not that is a good idea, I suggest that you speak with your legal counsel about your particular situation, okay? Now, repairs after casualty, and a casualty can include hurricanes, for example. The statute addresses repair obligations after a casualty event, okay? So if we're talking about who's responsible to repair what after an insurable casualty loss, okay, you have to go to the statute. If we're talking about who is responsible for maintaining what portion of the condominium or unit that is unrelated to a casualty loss, it's just a maintenance repair issue, then you have to go to your declaration to see what are the repair obligations of the owners and the association. So, with regards to casualty, any portion of condominium property that must be insured by the association against property loss, which is damaged by an insurable event, must be reconstructed, repaired, or replaced as necessary by the association as a common expense. So this would include, for instance, drywall, right? So if you had a hurricane and there was wind-driven rain come into the unit and damages drywall, that would be the responsibility of the association to remediate. Unit owners, however, bear some responsibility, and they are responsible for the cost of reconstructing any portion of condominium property for which unit owners require to carry property insurance. Okay, so remember those items I mentioned in the prior slide, like kitchen cabinets and floor, wall, ceiling coverings. So if any portion of the unit that the owner maintains or supposed to maintain insurance on is damaged, that's going to be their responsibility to remediate. And they're also responsible for any portion of the condominium property not paid by insurance proceeds if such damage is caused by the intentional conduct, the negligence, or the failure of the owner to comply with the declaration. The cost of any such reconstruction, if it's undertaken by the association, well, that can be charged to the unit owner and then enforced as an assessment. And as I just mentioned a few seconds ago, in the absence of an insurable event, the association or the unit owners are responsible for repairs, replacement as determined by the maintenance provisions of the declaration. All right, and let's quickly go through conflicts of interest and then we're done. So just a few more minutes. All right, directors and officers and relatives of directors and officers have to disclose to the board any activity that can reasonably be construed as a conflict of interest. Well, the statute says that there is a rebuttable presumption that conflict of interest exists if any of these two items occur. One, if either a director, officer, or relative of the director or officer enters into a contract with the association for goods or services, or they have an interest in an entity that is looking to enter into a contract with the association for goods and services. Now, the statute doesn't prohibit the association from entering into a contract with a director, officer, or an entity in which these individuals have an interest, but it does set out certain requirements that you have to follow in order to properly authorize that contract or transaction. And these requirements are set forth here on the slide. So if a director, an officer, or a relative of a director or an officer proposes to engage in activity that's a conflict of interest, well, that activity has to be listed, and then all contracts and documents related to that activity must be attached to the meeting agenda. And then the statute specifically says that at least 2/3 of the directors present at the meeting have to vote in favor of that contract or transaction. The director, officer, or relative of the director or officer who has this conflict of interest can attend and be present at the board meeting, at which the board's going to approve the contract, and they're authorized to make a presentation. Okay, but then once they make the presentation, they have to leave and let the board vote. Now, the presence of that interested director, officer, or relative of the director or officer can be counted towards quorum. So even if they leave, their presence is counted towards quorum. And then the director or officer who is a party or has an interest in that specific transaction or contract has to recuse himself or herself from the vote. If the board votes against the proposed transaction, then the director, officer, or relative of the director or officer must notify the board in writing of his or her intent not to pursue the proposed transaction, or they have to withdraw from office. And then at the next either regular or special meeting of the owners, so either the annual or any special membership meeting, the existence of the transaction has to be disclosed to the members. And then the members have the opportunity to vote against that transaction. So if any owner makes a motion to terminate that contract, well, then the contract can be canceled by a vote of the majority of the members present. Now, if the owners do terminate that contract or that transaction, then the association would only be responsible for the the cost of goods and services provided through the date of the cancellation, and the association wouldn't be responsible for any termination fees or liquidated damages under the contract. A contract that is entered between a director or officer or relative of a director or officer and the association that has not been properly disclosed as a conflict of interest is voidable and can be then terminated upon the consent of at least 20% of the voting interest of the association. And again, the association managing condominium with 150 more units must post digital copies on the website of any contract or document regarding the conflict of interest. There is a similar statute regarding conflict of interest involving your community association manager or your management firm. And essentially it's substantially similar. Essentially, there is a rebuttable presumption that a conflict of interest exists if either the property manager or the management firm is looking to enter into a contract with association for services, or they have a interest in another entity that is looking to enter into a business relationship with the association. So sometimes you might have a management firm that is a parent company or owns a landscaping business or an accounting business, and they might suggest for the association to enter into a contract with this separate entity. Well, they'd have to first disclose this conflict of interest, and the association would have to approve, or the board would have to approve that transaction in accordance with the statute, which is very similar to the requirements that I just mentioned for approving a conflict of interest with a director or officer. So I won't regurgitate that here. They're in the slides and you can review them at your leisure. And I think I'm going to stop